Meeting of the State Election Board. First item on the agenda today is the invocation, the Pledge of Allegiance. Member Johnson, would you please lead us in prayer?
Let us pray. O God, source of all, Father of all mercy, give us comfort, give us wisdom, give us discernment. Make us mindful of those who are in any adversity and any need. Bless the work that we do today and be with us always. Amen.
Amen. Member Gazal, would you lead us in the Pledge of Allegiance, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Justice. We have some remaining items from yesterday's agenda that we're going to go through first, and then we'll move into the hearing of the petitions after we finish those cases. And we have a special.
Trying to get ready.
Oh.
They can hear you.
We have a something else that we'll add to the agenda once we get through the rest of these cases. The first case that we will hear this morning is SCB 20223-344 Fayette County ineligible voter, November 2022. It's on tab 29. Yes, investigator.
Georgia Secretary of State initiated this investigation following the receipt of an online complaint
regarding an unqualified voter who was allowed to vote in the general election on November 8th, 2022. On November 4th, 2022, the unqualified voter, Cicely Lacey, arrived at the Fayette County Library for advance voting for the November 8th, 2022 general election. According to poll worker Jean Elmore, she checked Lacey in via Easy Vote, verified her information, provided a signature, and printed the absentee ballot application. Elmore advised there were no red flags or error messages from Easy Vote. Elmore advised in her experience with Easy Vote, if there was an alert or error, a message is generated and the check-in process is automatically stopped. However, Elmore advised nothing appeared to be out of the ordinary. She advised Lacey to go to the poll pad check-in for a voter card. Elmore advised after using Easy Vote, she entered the voter registration number into ElectionNet and an alert/error message appeared. Elmore advised by then, Lacey had voted and left the polling place. The issue was Lacey had a registration date of 10/12/2022, but the registration cutoff date was 10/11/2022, and this is what made her unqualified. The investigator later interviewed Election Director Brian Hill for Fayette County, who advised that this issue occurred because the worker rushed through the process to get through the voter lines. Hill advised that poll workers must check ElectionNet before sending the voter to the poll pad for an access card. Hill advised that he always makes it clear during poll worker training that Easy Vote is not the official state system. Although Easy Vote shows voter information, it is exclusively used for signatures for absentee ballot applications and voter oaths. On 8/25/2023, contact was made with the voter. She verified her identity, Mrs. Lacey that is. She verified her identity, her address, and confirmed she was a registered Fayette County voter. Lacey confirmed she participated by absentee voting in the general election on November 8th, 2022. Lacey confirmed she was a first-time voter and advised she was unaware of the October 11th, 2022 deadline that prevented her from being eligible to participate in that election. Lacey's immediate response to the deadline was to question why she was allowed to vote in the first place. So based on the evidence, based on the investigation, there is evidence to suggest that Jeannie Elmore violated OCGA 21-2, 245A, and SCB Rule 183-1-12-.11.2 sub A when she failed to check the voter registration system to confirm a voter's eligibility to vote and allowed an unqualified voter to vote in a primary or election.
Is there a respondent here from Fayette County? Are there any questions from the board?
Yes, thank you very much for this report. And it seems quite clear that the problem in the system lies with the Easy Vote system itself. Now, Easy Vote is only used during advanced in-person voting. Is that correct?
Yes, that's what it was used, yes.
Do you know whether or not, moving forward, Easy Vote will still be used by counties?
Yes, there are some counties that still utilize Easy Vote, yes.
I think it's really critical that, that counties understand the limitations of this system. If the system does not flag voters who are not qualified to vote in this particular instance, then these are votes that never should have counted. And I would ask that, I don't know that we have anybody from the Secretary of State's office here. I would ask that the Secretary of State office issue an official guidance and provide training to counties that use Easy Vote specifically about this loophole.
Yeah.
Because this never should have happened. The voter is not at fault, but, and the county is at fault if they're not sufficiently training their people, that Easy Vote is not to be used as an alternative to the check-in system, because it cannot be.
Yeah, it looks like the director, Brian Hill, said that they're trained to not rely on Easy Vote, that they need to check the system before they allow someone to vote, but it looks like she rushed through that process, and then after the person was already gone is when she checked, and by then, the vote was already cast.
I have experienced in the past where counties use Easy Vote and they don't actually sync it up with the state system for days.
Yeah.
So I know that in past elections, Easy Vote has been used as the check-in system, and this is a real problem.
Okay.
Are there any other questions from the board?
I'm just trying to figure out why on earth we use Easy Vote. If you can't verify that someone's eligible to vote that day, why on earth do we use it?
To fill in things quickly, I think. So instead of, it populates
Right.
automatically. So people don't have to type in, fill out information.
But doesn't
Somebody made a, it's kind of called a glorified pen is one of the statements that was from the investigation. So it just fills out things quickly.
Well, then I'm going to actually go a little bit further, because we don't need it anymore now that we have updated poll pads and an updated system, that the poll pads can be used for early voting. This is the first cycle in which we can do that. I am going to request that the Secretary of State's office evaluate whether or not Easy Vote should still be a certified, or a system that is allowed even. Not just that they need to warn counties. I want a serious inquiry whether or not counties should be allowed to use it moving forward. And I would like a report back from the Secretary of State's office at our next meeting, at the August meeting, not July, but in the August meeting.
Would you please detail your request to Alexandra, and she'll forward that to the Secretary of
Yes.
State's office?
Absolutely.
Thank you.
In order to sort of use this as a vehicle for that discussion, should we simply continue this case till August? This is a question.
Yeah.
Should we simply continue this case to August and have, with the request from the Secretary of State's office to come in so we can have this discussion? And using this case as an example of the problem with the Easy Vote. That's my question.
I would agree with that.
For that reason, I will move to continue this case. And then if Alex could please ask Secretary of State's office to come and let's have that discussion.
We have a motion by Member Lindsay to continue this case to the August meeting. Do we have a second?
Second.
Having a motion and second. Any discussion? Hearing no discussion, all those in favor of continuing this case to the August meeting signify by saying aye.
Aye.
He's an aye.
Any nays? Hearing no nays, The vote passes 4-0. The next case that we'll hear is SEB 2022-356, Fulton County Welcome All Recreation Center tabulation issues.
The Secretary of State's office initiated this investigation after it received a complaint alleging that a poll manager tabulated and posted results prematurely at the Welcome All Recreation Center, an advanced voting precinct for the December 2022 general election runoff. The allegation that the poll manager prematurely tabulated and posted election results at the Welcome Center during the advanced voting period was substantiated. The investigation found sufficient evidence to show that the poll manager at the Welcome All Center polling location erred by prematurely tabulating the ballot scanner and affixing the tabulated results taped to the door of the polling location at the closing of the precinct during the advanced voting period for the December 2nd, 2022 runoff. At the end of the advanced voting period, the poll manager is only required to shut the scanners down and wait for the main office to tabulate results in Election Day. The poll manager inadvertently chose to close the polls which tabulated the election results, and he subsequently posted the results for view, which should not have been done, as the polls do not close until the end of the election on Election Day. Martin inadvertently followed the protocol for closing the polls after the election was final. The potential violations are for SEB Rule 183-1-14 and OCGA 21-2-386-2A.
The respondents.
Good morning. This is another case where the facts are not in dispute. That is what happened. The poll manager had historically worked Election Day. He got confused and did the Election Day procedures instead of the advanced voting procedures. He has been disciplined. He has lost his job as a poll manager. He is also not working this election at all. And this mistake has been incorporated into trainings and into reminders. So we would ask that you agree with the Secretary of State's recommendation and just issue a letter of instruction in this case.
Are there any questions from the board?
Mr. Chair.
Yes.
So this is identical to the case presented yesterday from Clayton County. It's a chronic problem. It needs to be improved upon in all counties, not just Fulton County. That inadvertent closure of the poll and printing tabulation of votes is against Georgia election law, and it should not be tolerated.
I have one question. Attorney Brumbaugh, what happened to the tapes? Because here they were posted. Were they secured afterwards? When did Fulton County receive notice that this was posted, and what happened with the results?
Unfortunately, I can't answer that question, and my client was not able to come back this morning. I can certainly ask. I don't want to speculate, but I also want to advocate for my client and assume that it was handled. This was the end of the problem, and it was then taken care of. But I can certainly ask if that's important.
No, thank you.
Mr. Chair. Thank you for the report of handling the problem. And again, like yesterday, I make a motion that we direct the Secretary of State to provide clear guidance on what to do when there's an inadvertent closure of a poll from early voting or at any time, what the proper procedure and security to provide to those tabulation tapes so that the results are not available for anyone who wants to see before the close of Election Day.
So your motion is that this board will provide a recommendation to the Secretary of State to provide clear guidance on the early closing of polls?
Yes, I would, not just a request, I think my motion is to direct the Secretary of State to provide this guidance.
We have a motion from Member Johnson to require the Secretary of State to provide clear guidance on the early closing of polls. Is that correct?
That's correct.
Is there a second?
I'm not sure if we have the power to direct versus strongly recommend. Unfortunately, you know, the General Assembly in its infinite wisdom did not give us that explicit power. So, would you be willing to say strongly recommend rather than direct? Just so we can, just so we don't get into a squabble with someone?
I will amend my motion to strongly recommend.
I'd like to direct, but I don't think I have the power to direct. So let's just go with strongly recommend.
The motion has been amended by, Member Johnson that this board strongly recommend the Secretary of State provide clear guidance on the early closing of polls. We have a second from Member Jeffries. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, the motion is carried 4-0. Are there any other motions pertaining to this particular case?
Go ahead.
I move that we issue a letter of instruction to Fulton County as per the recommendations.
We have a motion from Member Gonzalez. We issue a letter of instruction to Fulton County. Is there a second?
Second?
There is a second. Any discussion? Hearing no discussion, all those in favor of issuing a letter of instruction to Fulton County on SEB 2022-356 signify by saying aye.
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 Any opposition? Hearing no opposition, the motion is carried 4-0. The next case we will hear is SEB 2023-035 Fayette County qualification fee issue. It's tab 32 in your binder.
All right, ready?
Yes.
Secretary of State's office initiated this investigation after it received a self-report saying that the city of Fayetteville inadvertently published the wrong amount for the qualifying fees for council post and mayor, a potential violation of OCGA 21-2-131, fixing and publishing of qualification fees. So ultimately, this particular allegation was substantiated. The initial qualifying fee that were posted by Valerie Glass, the city clerk, included a stipend which is not designated as a supplement, but instead to cover the mayor and council members' personal use of their vehicles, gas, and maintenance expenses. Once the city officials realized that the error in calculation had also been made by the previous clerk, the city passed a resolution defining qualifying fees. After the resolution was voted on and approved by the city council, a new publication was posted in the newspaper. The correction was posted in the newspaper on July 5th, 2023. The error was noted after the city of Fayetteville's finance director, Michael Bush, provided them with the correct fee amount. And looks like the incorrect fees were $468. The correct fee for mayor is $342. Incorrect fee for council member was $324, and the correct fee was $234.
Is there a respondent here from Fayette County? Other questions from the board?
I have a quick question. It seems from my reading of this that the correction was made prior to actually collecting any of the fees. Is that right?
Yes, that's correct.
So the corrected fees were what was charged to any candidate?
Yes.
Thank you. At the appropriate time, I would move to dismiss this based on they corrected the action.
Yeah.
No candidate was charged an incorrect fee, and it was inadvertent because this is unclear. And clarity is going to come when we get the Attorney General's advisory on what constitutes salary versus supplement.
Are there any further questions from the board? The chair will hear a motion.
I move to dismiss.
We have a motion from Member Gonzalez to dismiss. Is there a second?
Second?
There's a second from Member Johnston. Any discussion? Hearing no discussion, all those in favor of dismissing SEB 2023-035 Fayette County qualification fee issue signify by saying aye.
Aye.
Any opposition? Hearing no opposition, the motion carries 4-0. This case will be dismissed. The next case that we will hear is SEB 2020-292 Richmond County voter registration. It's tab number 35 in your binder.
This case has 3 allegations. The first one, John Buller alleged someone forged his mother, Martha Buller's signature on her absentee ballot for the November 3rd, 2020 general election. Allegation 2, Teresa Rogers alleged she observed a mail place around 50 absentee ballots in a drop box at the local courthouse. The third allegation, Richmond County election supervisor Lynn Bailey alleged her office located 17 voter registration applications and 1 absentee ballot they believed to be suspicious. For allegation 1, the voter application for Ms. Buller dated 9/15/2020 and the absentee ballot applications for 9/15/2020, 10/2/2020, and 12/7/2020 were pulled and signatures were looked at by the investigator. All but the 12/7/2020 were verified and signed in cursive. The 12/7/2020 was printed, and that was the document that was questioned. Ms. Buller was at Stevens Park Health and Rehabilitation Center and was in quarantine since March of 2020. And her son only spoke to her through a window, and he did not think his mother signed in print. She was assisted by Shani Ball, who was an employee at the time. Ms. Ball was employed from 2009 until December 18th, 2020 as a social worker. Ms. Ball was interviewed, and she stated she signed as the assisted person and advised Ms. Buller signed in cursive and in print. In the last 12/7/2020 application, Ms. Buller had passed away on 12/26/2020, so that allegation was unsubstantiated. Allegation 2, the complainant advised she and her husband witnessed a black male around 50 years of age, medium build, wearing glasses, and witnessed this male drop off what appeared to be 40 or 50 applications on October 20th, 2020, around 10 a.m. Travis Doss, the Richmond County election supervisor, reviewed their files and surveillance footage and found numerous black males wearing glasses. However, none of them appeared to put more than 1 or possibly 2 ballots in the drop box. The video was viewed from 8 o'clock until 11. And that allegation was unsubstantiated. The third allegation, the investigator was able to identify 3 canvassers who were employed by the outreach team during the registration period leading up to the January 5th, 2021 runoff. The canvassers were identified as Broderick Green, Talisha Jacobs, and Priscilla Brown. All 3 canvassers signed voter registrations as assisting that were flagged as suspicious by the Richmond County Election Office. Broderick Green signed as assisting Fanny Nelson, and she was listed as canceled due to being deceased. Mr. Green was interviewed, and he didn't remember registering anyone to vote or working for a registration organization in 2020. He also stated he only signed his name with a Y in between his first and last name. His signature card was pulled, and he signed his name without the Y on his registration dated 6/19/2021. The signatures on Mr. Green's past voter registration shared similarities with the signature on Ms. Fanny Nelson's voter application dated 11/25/2020. Talisha Jacobs signed as assisting a voter registration for Imani Meadows dated 11/30/2020. There was a second voter registration dated 10/4/2020. For Imani Meadows, and no one signed as assisting. Both registrations had different dates of birth, social security numbers, and signatures. The investigator spoke with Ms. Meadows, who advised neither signatures on the applications were hers. She also said Ms. Jacobs was her friend, and she gave Ms. Jacobs permission to complete a voter registration and does not believe she meant to commit any type of fraud. Ms. Jacobs was interviewed, and she advised that she was paid $25 an hour, and at first there was no quota. She was later told that if she didn't produce at least 10 voter registrations a day, she would lose her job, and she really did not want to lose her job. She looked at both signatures and said they both looked like hers. She said her intention was not to commit fraud, but merely keep her job. Priscilla Brown signed as assisting on 5 voter registrations for Stacy Pinkston, Michael Jackson, Ezra Lay, Stephen Brown, and Joanne Smith. The voter registrations were dated between November 30th, 2020 and December 7th, 2020. The investigator checked current address but was unable to locate Stacy, Michael, Ezra, and Stephen Brown. The investigator spoke with Joanne Smith, who reviewed the voter registration application and confirmed the signature was not her own. Ms. Smith remembered while shopping being approached by a black female who asked if she was registered to vote. Ms. Smith informed her she was already registered, but the lady said, "Let's fill one out just to make sure." Ms. Smith gave the lady her information, who in turn filled out the form. Ms. Smith said the lady never asked her to sign the voter registration application. The investigator spoke with former canvasser for the outreach team, Priscilla Brown, who reviewed the 5 voter registrations and identified the signatures in the person assisting section as her own. Ms. Brown claimed she only helped people fill out the registration, and if they had an inability to do so, it was her understanding that if she helped the voter in any way to include reading or explaining any part of the registration, she had to sign as assisting. Ms. Brown claimed she did not forge the applicant's signatures and said the cursive handwriting was not her own. The investigator showed Ms. Brown a past signature example Richmond County had for Joanne Smith, and she agreed the signatures looked different. Several times through the interview, Ms. Brown claimed the handwriting on Joanne Smith's application was not her own. Ms. Brown claimed she did not forge Ms. Smith's signature and said the cursive handwriting was not her own. She then apologized and said if she did something wrong, it wasn't intentional. Potential violations were for Broderick Green, Talisha Jacobs, and Priscilla Brown. For violation of OCGA 21-562 subsection A1 for fraudulent entries, unlawful alteration or destruction of entries, and unlawful removal of documents, neglect or refusal to deliver documents.
Is there a respondent here from Richmond County? Are there questions from the board on this case?
Yeah. The folks that hired these people, outreach, they're not a party to this case, are they? Are they a party? They're not a party. They're not a respondent, correct?
No, they confirmed that all 3 of them worked for outreach,
Yeah.
though.
Frankly, they should be a party. I'd like to see a file open as to them, because it would appear their training is deplorable, and perhaps even to the point of if they are requiring quotas for registrants, I believe that's a violation of our laws. And if they were a party right now, based on what I know right now, I would probably be looking at some very severe sanctions. So, I mean, that's my first comment. I am, as to them. As to the second allegation, you know, with the 50, it's my understanding that we had someone from the county election board review the tape rather than us reviewing the tape, correct?
Yes, he reviewed it from 8 to 11.
Yeah. Is that the time period that the woman said that she thought?
It was 2 hours before and 1 hour after he
Yeah.
reviewed it.
And I realize you guys are swamped and underneath a lot of time frame, but given the seriousness of the allegation of someone claiming that someone was literally stuffing with 50 ballots, I'd like to have somebody from our side actually look at the tape to make sure that there wasn't an irregularity. Is this sort of tape something that can simply be transmitted to you guys, or is that something that y'all will have to travel to see? I'm just sort of curious. Do you know?
I'm not sure. I'll have to ask the investigator.
Yeah.
It's likely a huge data file.
Yeah, but you know, you understand where I'm coming from. I mean, this given the fact that the allegation is of someone stuffing 50, that's a pretty serious allegation, and I'd like, and while I appreciate that the county election board did review it, given the seriousness of the allegation, I'd like to see one of our investigators look at it as well. And so, at the appropriate time, I'd like to continue that one. I would like to send the others matters to the Attorney General, and I'd like to open a file as to this organization.
He did interview the former deputy director of outreach team, who confirmed she worked for the outreach team during the 2020 election. She said that she worked for the organization and they did everything accurately and to the best of their ability. She was unaware of any of these issues until this point.
Yeah.
She also said that the canvassers during the first campaign were expected to work in the field and that they were trained not to sign on anybody's behalf. She said that would be highly discouraged. No, we don't sign anything on anybody's behalf.
Well, obviously, their training wasn't adequate. And so, like I said, I'd like to see a file open, complaint open as to them. I think that we have the power to do that. But like I said, at the appropriate time, I'll make a motion as to the third allegation to send to the Attorney General. And I'd like to continue the second allegation and give you guys a chance to look at it ourselves, given the fact that we're talking about 50 ballots allegedly being stuffed. I just want to run that one to ground.
Any other questions from the board? Chair will entertain a motion.
As to allegations, well, make sure I get it right here. As to allegations 1 and 3, I would move that these matters be referred to the Attorney General for further action.
And allegation 2,
Allegation 2, I was going to do that separately, but allegation 2, I would move that we continue that and ask one of our investigators to actually look at the tape as well, given the seriousness of the claim.
we have a motion to send allegation 1 and allegation 3 to the Attorney General for further investigation. Do we have a second?
Second.
We have a second from Member Johnson. Any discussion? Hearing no discussion, all those in favor of sending allegation 1 and allegation 3 of SEB 2022-292 Richmond County voter registration to the Attorney General for further investigation, please signify by saying aye.
Aye.
Any opposition? Hearing no opposition, the motion carries 4-0.
As to allegation 2, I move that ask that be continued and ask our investigators to review the tape, given the seriousness of the claim.
The motion's been made by Member Lindsay to continue allegation number 2 and ask our investigators to further review that allegation and look at the tape pertaining to that allegation. Is there a second?
Second.
We have a motion and a second to continue allegation 2, send it back to the investigator for further review of the tape. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, motion is carried 4-0.
Mr. Chairman,
Yes.
is there a motion to open a case on the outreach?
Yeah, I mean, is that the appropriate? Yes, I would move to open a case against, what's the name of the entity?
The outreach team?
Outreach team.
Who's going to be the complainant?
Do you want to
State
add them as a
election board.
respondent
State
or
election
to?
I'll tell you what, I think the easiest thing would be to add them as a respondent. Thank you very much. I appreciate my investigator knowing how to do this. I lean on her a great deal. Move that they be added as a respondent, and that the matter be taken up at the next hearing since the investigation has already been completed.
Okay,
To
so
give
have
them
their
an
part.
opportunity, to come and be heard and just see whether or not what remedy we need to impose this to them.
But they would be responding to allegation 3, correct?
Correct.
Which we've already moved to send to the Attorney General's office.
As to those individuals, but I would keep that issue open as to outreach.
Okay. There's a motion to add outreach as a respondent and request their presence at the next board meeting to respond to allegation number 3. Is that correct?
In terms of their conduct, yes.
In terms of their conduct in this issue. Is there a second?
Second.
We have a motion and a second to add outreach as a respondent to allegation number 3 in SEB 2022. We have a second. Any discussion by the board? Hearing no discussion, all those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved by a vote of 4-0. In this case, we'll hear is SCB 2022-036, Clarke County false ID card.
The Secretary of State's office received a complaint from a complainant, Jessica McFadden, who indicated that Oscar Lee Sutton Jr. received a voter ID card using her home address, and she does not know him. So on April 27, 2022, our investigator spoke with Elections Clerk Nathan Ork with the Athens Clarke County Elections Office. He gave investigator copies of Mr. Sutton's voter registration applications. Mr. Sutton registered to vote on both January 21st, 2022 and July 12th, 2021. After the July 2021 attempt, he was sent a letter informing him that he was a felon under sentence, therefore he could not register to vote. Mr. Ork also told the investigator that the photo and the ID would have been taken in person on the day he filled out the application. ElectionNet indicates that Mr. Sutton has no voting history. Our investigator later spoke with Mr. Sutton, who was then in Clarke County Jail for failing to register as a sex offender. Mr. Sutton claimed that the reason he applied for a voter ID card was because he needed an ID so that he could obtain a free government phone from a homeless advocate. He said that he could not use the address of the homeless shelters anymore, which he had previously used, so he decided to use an address where he resided in the past. He told the investigator that about 1 or 2 years ago, he used to stay at the address 130 Winchester Way with his former employer who owned a landscaping company. And that individual's name, Jason Call. He indicated that he lived at that address for about 6 to 8 months while between living arrangements. Mr. Sutton stated that Mr. Call eventually moved to a larger home, so he had to leave as well. Mr. Sutton was hopeful that when his voter ID card was mailed to Winchester Way, the current owner would have sent it back to the elections office where he would then pick it up. He told him that since applying for the ID, his tent caught on fire and he lost all his IDs. And then ultimately he was arrested for the charge. So the investigator later did speak with the former employer, Mr. Call, who confirmed that Sutton did work for him in the past. He indicated that the only time that Sutton was at his residence is when he was doing landscape work there, and that he never lived there with him. So ultimately, our investigation determined that Mr. Sutton violated 21-216B, qualifications of electors, which deals with felons being prohibited from registering to vote while under sentence, and also false registration, 21-561, where he put the information that he lived at that address when he really did not live at that address.
Is the respondent Oscar Lee Sutton here? Are there any questions from the board?
Yes. So has the respondent ever attempted to vote?
No, there's no voting history.
So isn't it true that you cannot get a county-issued ID card without registering previously? That it is, being a registered voter is a prerequisite to being issued this ID card? under state statute.
Yeah, I'm not certain.
I'm fairly certain that that is the case. And I can, if it's relevant, I'm happy to look that up. And the reason I say this is one of those tragic cases where the state is not serving its homeless population in the way that we need to. Because this is literally the only ID card with a photo that a person who does not have the rest of their IDs, which many people who are unhoused do not have access to the paperwork that they need. And you have to be registered in order to qualify for this ID card. People under these circumstances don't register in order to violate election laws and vote. They register so they can have ID, so they can access the services that they need. And this is a problem that only the legislature can respond to. Only the legislature can provide an avenue for people when they are leaving the carceral system to be given a photo ID with their information that is recognized as a government-issued ID. So again, more of a comment than a question, but I find this a deeply troubling case because yes, it is a technical violation, but some of our citizens are left without other pathways, and this is the least onerous pathway for somebody to actually try to access services that they are allowed to access, but not without the ID. And the address is also an issue. How do you cannot receive mail at a tent. I would move in this case to issue a letter of instruction, but I don't know where to send it to.
The problem is, and you do state the problem for those who are homeless, and I'm not without sympathy, and I'm not in disagreement as to action needs probably to take place by the General Assembly. When we created these ID cards, they were for the specific purpose of assisting folks who did not have a driver's license or another ID to be able to utilize an ID in order to vote. That's why we set it up. I voted for it, I think, in 06 or 07, something like that. That said, I worry about the precedent of simply a letter of instruction or a dismissal. What kind of precedent that set in terms of encouraging folks to do the same, which I think is dangerous. And so for that reason, and I will leave it to the Attorney General to try to come up with a reasonable resolution in this particular case, but I cannot simply do a letter of instruction and thereby, and by doing so, encourage others to follow suit, which will potentially add people to the rolls that shouldn't be added to the rolls. And for that reason, I will at the appropriate time move to send it to the Attorney General's office. Happy to have you send along your concerns and let them figure out an appropriate penalty in light of the situation. Encourage my friends in the General Assembly at the appropriate time after the second Monday in January to maybe come up with a remedy in terms of IDs that aren't necessarily linked to voters, but I worry about the precedent of simply a letter of instruction.
So I would like, go ahead.
Yeah, it appears he's incarcerated right now, so we know where he is now.
I would like to add, there are two types of photo IDs. One is a state-issued photo ID that requires the appropriate documents of authenticity and residency and citizenship to get a card in the state of Georgia. But there's also a voter ID card that is different. And a person can walk into an election office and just get a voter ID card. Because I took my 99-year-old mother into Fulton County and they produced a voter ID card with her. She had not lived in Georgia before. She had not registered to vote in Georgia before, and they simply took her word for it and gave her a voter ID card. So I think there is a problem with proper issuance of either ID card.
Sure.
At the appropriate time, Mr. Chairman.
Any further questions from the board? The board will, the chair will entertain a motion.
I move that the matter be referred to the Attorney General for further action.
Second.
We have a motion from Member Lindsay and a second from Member Johnson to refer this matter to the Attorney General for further action. Any discussion?
I would add with that referral that I believe a cease and desist is an adequate remedy in this case.
I'm okay.
We have a request to amend the motion to add a cease and desist order as an appropriate remedy to the case. Member Lindsay, it is your motion. Would you accept that amendment?
Yeah, I'll accept it.
We have a amended motion to refer this to the Attorney General for further action with the recommendation of a cease and desist order being the appropriate action. Do we have a second?
Second.
We have a second. Any discussion? Hearing no discussion, all those in favor of referring case SEB 2022-036 Clarke County false ID card to the Attorney General for further action with the recommendation that a cease and desist order be added or be the appropriate action, signify by saying aye.
Aye.
Any opposition? Hearing no opposition, the motion passes 4-0. SEB case 2022-047, Rockdale County, Durand qualifying issue has been continued to the next board meeting. The next case on the agenda is SEB 2022-138, Chatham County miscellaneous. Is there a respondent here from Chatham County? No? Okay. Investigators, please.
A citizen by the name of Gregory Olson alleged that he sent an absentee ballot application for his wife, Robin Olson, his father-in-law, Robert Conklin, and himself for the June 21st, 2022 general primary runoff election. Mr. Olson received his ballot, but alleges that his wife never received her ballot, and his father-in-law did not receive his ballot in a timely manner. The investigator spoke with Mr. Olson, who stated he requested an absentee ballot for himself for that election. All three applications were sent on the same day, May 11th, 2022. Mr. Olson received his ballot June 16th, more than a month after requesting. Mrs. Olson never received her ballot, and Mr. Conklin received his ballot on the day of the election, which did not give him any time to send it back. Mr. Olson was able to send his ballot back in time to have it counted. Mr. Conklin's ballot was sent to their home address instead of the temporary address, which was then forwarded to the temporary address by the Postal Service. Mr. Olson checked on the status of his wife's application, and it appeared that the elections office never received it. He indicated that he has had problems with the Postal Service losing mail, and that it's very likely they lost her application. The investigator spoke with Mrs. Olson and Mr. Conklin, who verified that Mr. Olson sent their absentee ballot applications by mail to the Chatham County Elections Office. Mrs. Olson advised she did not receive her ballot, just as her husband stated. The investigator later spoke with Chatham County Chief Registrar Sabrina German, who stated the absentee ballot clerk who processed the absentee ballots is no longer with the Chatham County Registrar's office. She wrote a note on the side of Mr. Conklin's absentee ballot application for the June 21st, 2022 general primary runoff, indicating that it was already processed. Mrs. German believes this was an oversight on their behalf, as the ballot was sent to the same address as the previous absentee ballot. Mrs. German did not receive an absentee ballot application for Ms. Olson for the June 21st, 2022 general primary runoff, so a ballot was never sent to her. Mrs. German provided investigator the copy of Mr. Olson and Mr. Conklin's absentee ballot applications from the May 24, 2022 general primary election, and the applications for the June 21st, 2022 general primary runoff election. A search of Jarvis by the investigator revealed that Gregory Olson requested a ballot on May 11th, 2022, as stated. The ballot was issued on June 10th, 2022, almost a month after the request was made. Robert Conklin requested a ballot on March 30th, 2022, and the ballot was issued on June 10th, 2022. Mr. Olson and Mr. Conklin's ballot were not sent within 3 days, violating OCGA 21-2-384 sub 2 regarding mailing of ballots.
Once again, is there a respondent here from Chatham County? Other questions from the board?
Well, first off, the comment. Unfortunately, we also don't have jurisdiction of the U.S. Postal Service, but it would be nice if we did sometimes. Were the people able to vote? They didn't get their absentee ballots. Do you know whether or not they actually?
The one was able to vote.
The
complainant was able to vote. The father-in-law was not able to vote, and then his wife never received anything. There was no record of anything being
I understand,
received.
but do you know whether or not she was able to vote or not?
No, she was not.
So those two were
not able to
basically by
vote.
virtue, well, there's a question as to whether or not Chatham County got the third.
There's no
one.
record of it whatsoever.
But as to the second one, there's no question that they got it. They just didn't get it back to the man in time, and as a result, he was denied his right to vote, his ability to vote.
Correct.
All right.
Any other questions?
My comment there is that, when election officials make a mistake, but we still see someone's right to vote not being infringed upon, I think we primarily work toward remedial efforts and make sure that mistakes don't happen again. But when someone is actually denied the right to vote, that becomes a little bit more serious matter for us to be concerned about. Chatham County isn't here also, I might add, to basically explain to us how they fixed this problem so it doesn't happen again. I want to point that out, even though they were invited. I want to make sure no one from Chatham is here. And so that's that. So we don't know whether or not what type of steps they've undertaken to make sure.
It looks like that clerk is no longer an employee
I
there.
appreciate that, but I'd like to make sure that that otherwise necessary remedial steps have been undertaken. And that's one reason why we encourage them to come, and we try to work things out immediately rather than send it to the Attorney General. But when we don't have a county showing up to sort of talk to us about how they have worked to fix problems, that leaves us with fewer options here, except for a more harsh one. Just want to point that out. We have a lot of folks from counties around the state who watch in on this, and that's the lesson I want to make sure they understand. If there's a mistake that's been made, if you come here and you before coming here you have taken the necessary steps to correct a problem, we're more willing to work with you. But if you don't show up and to reassure us that this sort of thing won't happen again, we're left with no other option but to send it to the Attorney General. So at the appropriate time.
Perhaps Mr. Lindsay would make a motion to continue this and subpoena Chatham County.
Chatham County were they notified?
Yeah, the
They've already
Board of
been notified.
Elections and the Board of Registrars.
Yeah, they were already on notice to come.
But were they subpoenaed?
They didn't have to be subpoenaed. They were notified that there was an action against them, and that they had the right to come. Subpoena is not necessary in this situation for us to send on to the Attorney General. They are the respondent, right?
Yes.
It's not the clerk that's the respondent. The county's the respondent. At the appropriate time.
Any other questions from the board? The board will entertain a motion.
Move to refer the matter to the Attorney General's office for further action.
We have a motion from Member Lindsay to refer this case to case number SCB 2022-138 to the Attorney General for further action. Is there a second?
Second.
We have a motion and a second. Any discussion? Hearing no discussion, all those in favor of sending SCB 2022-138 Chatham County to the Attorney General's office for further investigation signify by saying aye.
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 Any opposition? Hearing no opposition, the motion carries 4-0. The next item on the agenda is SEB 2022-186 Grady County challenged votes. It's tab number 40.
The complainant filed a written challenge against an elector with the Grady County Board of Registrar's office. The complainant alleged that the respondent, Brandon Phillips, had not lived at the residence he was registered at for the last 2 years. She reported the residence was sold on April 26, 2021. The complainant states the respondent voted in 2 elections after the residence was sold, and he failed to submit a change of address to the registrar's office. She advised the Grady County Registrar's Office did not set up a hearing, but they contacted the respondent, and he submitted a change of address to a residence within Grady County. The complainant provided a letter to the Chief Registrar challenging the respondent's voter registration status. She alleged that the respondent resides in Tallahassee, Florida, and that he voted in the May 24, 2022 general election and the June 21, 2022 general primary election runoff in Georgia. An ENET inquiry revealed that the respondent did vote in person for the May 24, 2022 and the June 21, 2022 general primary election runoff in Georgia. The investigator found through the tax assessor records that the respondent purchased the home he is currently registered at on August 2, 2022 for $0. The search of the Florida voter records showed that the respondent is not a registered voter in Florida. The chief registrar contacted the respondent, and he advised him that if he did not live at his current registered address, then he needed to change it. The respondent changed his registration from West Broad Street to Duncan Road, both within Grady County. The investigator requested a copy of the board minutes where they discussed the challenge and was advised that the meeting was not recorded. The chief registrar said she did not deny the challenge, and she did not feel a need to proceed because the respondent changed his address. The chief registrar acknowledged that she was aware of the election code regarding the right of an elector to challenge another elector. The investigator attempted numerous times to contact, by phone call, email, certified letter, and physically went to the house, the respondent, with negative results. Potential violations are for Grady County Chief Registrar, Grady County Board of Registrars, that there's evidence to suggest OCGA 21229. And then Brandon Phillips, there's evidence to suggest he violated OCGA 212218, subsection C.
Are there respondents here from Grady County Office of Registrar or the Board of Registers? Or is Brandon Phillips here to respond? Seeing no respondents, are there questions from the board?
Same issue as before. And let me also, to make sure folks understand, we have worked very hard over the last 2.5 to 3 years to become more of a collaborative body with our county election boards, to not just be the ones to impose a stick, but to also to work with them to make sure that that past mistakes are rectified and then put into place the proper procedures. When we don't have folks come and talk to us about how they have fixed problems, it leaves us little other alternatives.
Are there any other questions from the board?
I wanted to just make a real quick clarification. One of the respondents is the voter, Mr. Phillips, correct?
Yes.
And it was discovered through the investigation that Mr. Phillips simply moved within the county. Is that correct?
Yes, he does not live in Florida.
Correct, okay. Then I would split, I would have 2 motions. At the appropriate time, I would move that we issue a letter of instruction to Mr. Phillips, because he was still allowed to vote throughout, even when his registration was at his previous address. So he failed to update his address, but he was still allowed to vote in person because it was within the same jurisdiction. So I would move that in the case of Mr. Phillips, that we issue a letter of instruction as a respondent and not refer Mr. Phillips to the Attorney General's office.
within the same jurisdiction can still oftentimes lead to you having different people to vote for.
Correct, which is why I would not dismiss. I would issue a
And if I
letter of
lived across the
instruction.
street, I'd vote in a different congressional district than the one I'm voting in, for instance.
I think
Whether
that is something that I wish, that I would hope our counties and our state would publicize the requirement to re-register when you move, even if it is simply across the street, much better. But you do not lose the right to vote when you move within your jurisdiction.
Are there any other comments from the board or questions from the board?
I'm wrestling with it, to be candid with you, and I'd love to hear from some of the other people, because a part of me agrees with you, but part of me also goes, by virtue of wherever they move to, they could potentially have voted in a race that they did not have a right to vote in, and therefore they would be canceling out somebody else's vote potentially as a result of that. So I don't know, but on the same token, I hear you, they did have a right to vote in Georgia.
Yeah.
But they may not have had the right to vote in some of the races that they voted in. And I'm candid with you, I'm going back and forth. I would love to hear from, I know we got Rick on the phone and we got Jan as well. I'd love to hear their thoughts as well.
Would you consider sending it to the AG with a recommendation for a letter of reprimand for Mr. Phillips?
We have the authority to issue letters of reprimand.
Yeah. At a minimum, I want to send a letter of reprimand. Yeah, I can go along with that.
Member Johnson, comments or questions?
Well, moving within a jurisdiction is a reasonable allowance, but certainly moving out of a jurisdiction requires re-registration or updating the voter registration. I was under the impression that the respondent actually did live in Tallahassee, but I probably misread the investigative report, and that the registrar just made up an address within the same jurisdiction. So if he stayed within the jurisdiction, I'd say a letter of reprimand would be appropriate.
I'll make that motion.
Any further questions or comments from the board? The chair will entertain a motion.
As to the Grady County, I move to refer the matter to the Attorney General. And as to, if I can do it all at the same time, as to the individual voter, I would move that for a letter of,
Let's do this in two different motions.
yeah, move to refer the county to the Attorney General.
We have a motion to refer the Grady County to the Attorney General for further action. Is there a second?
Second.
We have a motion and a second to refer Grady County to the Attorney General for further action. Any discussion? Hearing no discussion, all those in favor of referring to Grady County to the Attorney General for further action on SCB 2022-186 signify by saying aye.
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 Any opposition? Hearing no opposition, the motion carries 4-0. The chair will entertain another motion.
As to the individual voter, I've moved for a letter of reprimand.
We have a motion to send a letter of reprimand to Brandon Phillips relating to SCB 2022-186. Is there a second? Second. We have a motion and a second to send a letter of reprimand to to Brandon Phillips relating to SCB 2022-186. Any discussion? Hearing no discussion, all those in favor signify by saying aye.
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 Any opposition? Hearing no opposition, the motion carries 4-0.
Oh, everybody hears him saying aye. So it's working pretty good.
The next case on our agenda is SEB 2022-211, Fulton County, absentee ballot fraud. Mr. Investigator?
The Secretary of State's office initiated this investigation after it received a complaint from Jessica Danielle Sibley alleging that someone received and completed an absentee ballot in her name for the May 2022 general primary, a potential violation of Official Code of Georgia annotated 21-2-596. On or about September 9, 2022, we received this complaint alleging what I previously stated. She's concerned that someone had used her name to fraudulently cast a vote. Complainant indicated she received excessive phone calls, text messages, and mail from political parties about voting. She then went online to her My Voter page and realized that someone had cast a vote in her name. The complainant stated that she did not vote in the May 2022 general primary. Fulton County Department of Registration and Elections checked into the matter and sent a copy of Jessica Sibley's application for in-person absentee ballot from May 16, 2022 for the May 24, 2022 election to the investigator. This voter has a date of birth of June 27, 1984 and an address of 525 Park Drive, Northeast Atlanta. The complainant has a date of birth of May 15, 1987 and a different address. Both have different middle names. The application for in-person absentee ballot presented at the Ponce Library polling place on May 16, 2022 was approved and verified with the incorrect voter registration number by Carisha Bush. The investigation found sufficient evidence to suggest that the election official erred and gave credit for the vote to the wrong Jessica Danielle Sibley instead of the correct voter, Jessica Laurette Sibley. Based on the information provided on the application and the signature, no findings that voter fraud had occurred. So the potential violation is SEB Rule 183-1-12-.11 regarding conducting elections, which stipulates that when a person presents himself or herself at the polling place for the purpose of voting during the time during which polls are open for voting, the person shall complete a voter certificate and submit it to the poll officer. The poll officer shall verify the identity of the person and that that person is a registered voter of the precinct, and if so, shall approve the voter certificate and enter an appropriate designation, et cetera, et cetera. So.
Respondents, please.
Thank you. Yes, again, the facts really are not in dispute here. The only thing I would add is that this arose in a situation in which the technology was not working and the poll worker was forced to use a paper spreadsheet. And so she saw Jessica, I guess, Marcus Sibley, and anyway, she just accidentally checked the wrong person off. It was a mistake. She has submitted, as he stated, she's taken responsibility, submitted a letter of apology. This was a one-off situation. It's not indicative of a trend or a pattern. It's not fraud. The poll worker has been counseled, and so we certainly appreciate and share this board's concerns about getting these things right, and no one wants this to happen, and hopefully there won't be any technical difficulties, because I think absent having to look at small lines and little text, this would not have happened. So we will just defer to your judgment as to what your pleasure is.
Do you know of any other mistakes made by this individual?
I do not. And I don't know of any other similar. I asked as part of my research for this morning, is this a pattern or a problem? And no.
How long has she been employed as a poll worker?
Unfortunately, I didn't ask that question. I think she still is working. I'm not sure if she's working this election, but she has been counseled That's part of the policy. When a poll worker makes a mistake, the poll worker is brought, unless they're disciplined, unless they're fired. But if it's a situation where it's something they can learn from, the poll worker is brought in and the poll worker is counseled and turn it into a learning experience.
Did she readily admit to her mistake?
She did.
Mr. Chair, I have a question.
Sure.
Fulton County. I recall that a spreadsheet was required to be used for that election, and it was actually, was it a paper spreadsheet or on a computer?
Well, I can just quote you the statement from the advanced voting trainer. He says, we were forced to process many voters manually using the provided voter list in Excel format from the Fulton County via jump drive. Each clerk was required to look up the voter manually, on the Excel spreadsheet.
Correct. So, yeah, it was on a laptop, I believe, for that
Okay.
election. And so they had to look up each one, which was quite tedious and would be subject to sort of picking the wrong one, and they had to find the right combination code and such. But I can't figure out how Sibley and Bush, they're not even close in the alphabet. Were the voter registration, how were they next to each other that this poll worker
Bush made the mistake. Bush is the poll
Oh,
worker.
I'm sorry.
Who made the mistake. There were two women named Jessica Sibley,
okay.
and
They were next to each other.
they gave the credit to the wrong Jessica Sibley. So, yeah.
Thank you.
Are there any questions from the board?
Well, in contrast to the others, it didn't show up, it didn't explain, it didn't demonstrate that certain remedial action had been taken. In this particular case, it did show up. They did sort of go through the remedial action. So I'm debating between a letter of instruction and a reprimand. Did anyone, no one was denied the ability to vote, correct?
No, because apparently the woman who got credit for voting, according to the investigators, didn't ever want to vote. So, no, I don't think anybody lost their ability to vote. It's not like that woman showed up and wanted to vote.
Yeah.
She got contacted after the fact.
She checked her page and saw that there was credit for voting there. She didn't vote in the election herself.
That's, thank you for that, I remember that now. I would do a letter of instruction, Mr. Chairman. And so,
I want to make a comment that over-prosecution is a problem in this country. And someone who admits to a mistake, makes an error like that, should not be prosecuted if they're trained and accepted responsibility for their actions.
and for that matter, for that reason, I think a letter of instruction would be sufficient. That's my motion.
Second.
The chair's received a motion from Member Lindsay to give a letter of instruction. There was a second by Member Johnston. Any discussion? Hearing no discussion, all those in favor of sending a letter of instruction signify by saying aye.
Aye.
Any opposition? Hearing no opposition, the motion passes by 4-0 vote. And that concludes day one of our agenda. The chair has received a request for a 20-minute recess to handle personal business. Without dissent, the chair will move to recess for the next 20 minutes. We shall return at, well, let's make it 11:10. We'll return at 11:10, which is just slightly longer than 20 minutes to handle our business. Thank you.
Thank you.
Promulgation of state election board rule presented by Bridget Thorne. And I think that what we will do is ask the petitioners to speak for about 15 minutes max and tell us why this rule is needed and proposed, and then we will open it up to questions and comments from the board.
I am Fulton County Commissioner Bridget Thorne, but today I come to you as a private citizen, a former 9-year Fulton County manager, election manager, and as an advocate for election integrity on a statewide level. My rule here is to build trust in our elections, which is lacking, especially in Fulton County, the county that I represent. And my 9-year history, I've seen a lot of reasons to lose trust. My main concern is that the County Board of Registrations and Elections have a very, very important role. They provide the oversight of our elections. Georgia Code 21-2-70 says they have the critical duty to inspect systematically and thoroughly the conduct of the elections. It goes on to say their duty is to receive from the poll officers the returns of all primaries and elections, to canvass and compute the same, and to certify the results. Therefore, of such authorities may be prescribed by law. But it seems in Fulton County, we are seeing that the board is just their duty to sign off. It's their ministerial duty to sign off on election results. But a common sense rule like this one would require that they have to check the number of ballots and the number of voters, and the two must be equal. As if anyone checks their checkbook, you have to have things even. But in Fulton County, it seems like that's not a necessity. We'll figure it out later, or we may never figure it out at all. Let's go through just a brief history of Fulton County. You guys discussed November of 2020, where 3,000 ballots were double scanned. If you had a law in place, maybe you wouldn't just be finding out that there was over 3,000 ballots double scanned. Maybe you would have found it out on the day that they were scanning those ballots, that the numbers were off. In November of 2020, in hindsight, looking back, a majority of the board would not have certified that election, looking back. I want to repeat, 3 out of 5 members of the board of a Fulton County Board of Elections would not have certified the November 2020 election had they had materials prior to certification. I want to go on to January 2021 election. They had to recertify that election on January 18th. Dominique Olamo forgot to upload results for Milton MLO1A and MLO1B precincts. Well, it didn't change the outcome of the election, it was just a mistake. But maybe that would have been found prior to the election and not require recertification 2 weeks later. In November of 2021, a municipal election, they had to recertify that election as well. It was a small amount, it was a small election, but they had to recertify because they found more votes somewhere. In May of 2022, you guys sent them a reprimand because they failed to upload 1,300 votes. Maybe if they had looked, if they had checked the number of voters with the number of ballots, they wouldn't have to recertify. Let's go on to November. This most recent November municipal election, 2023. They knew it was a close race, so they did everything beforehand. They had to recount beforehand, and they came up with a different number. So they basically did it on the front end of going ahead and doing a recount before certification. But who says which count was the right one? Was it the election day count, or was it the rescanned account? And by the way, they lost a box of ballots and they had to rescan again and delay their certification. A frustrating thing to me is that the Democrat Party, an attorney for the Democrat Party, sent out letters to several counties in the state of Georgia, telling them that it is just their ministerial duty to approve whatever results are presented for them. In March of this year, 2 BRE members in Fulton County requested documentation before they certify, so they can accurately project if they have the equal number of ballots with the equal number of voters, and they were denied. They were told they'd have to pass some new bylaws, that they don't do it this way, which is ridiculous. So I propose new rules in pursuit of the Rule 183-1-1.01 to adopt these new rules that will enable the board to have the materials to properly canvass and look at all the returns before they compute any votes. They must compare the number of unique voters who participated in the number of ballots cast for each precinct prior to time of certification. The county has a list of all people who voted absentee, advance voting, and in person on election day, and provisionally. So the board should have these numbers, these figures, before they certify their elections. If the number of votes for candidates exceeds the total number of people who voted in a precinct, that discrepancy must be examined by the board. In fact, the law says that no votes from that precinct can be recorded until the discrepancy is first investigated. So I'm just asking that you guys will adopt a rule that will go through and make sure that discrepancies are solved on the front end before certification, instead of 4 years later trying to rectify a situation and the board has no control over it. I also would like to add we need accountability. And Mr. Lindsay, in the newspaper, they quoted you saying that you wanted to bring trust and accountability. I feel like this rule will give the citizens the trust in Fulton County, which is very much needed. And that's all I have to say. Thank you.
Thank you, Ms. Thorne. I struggle a little bit with this rule the way it's written, because I don't want our board to exceed what the legislature has put into the statute. And I agree with you that nobody should be forced to certify something unless they've had the documents to look at first. It's ridiculous to ask somebody to certify something when they don't know what the results were, except for some numbers that were provided to them. I just have concerns on whether, and maybe the other board members can speak to this, whether this exceeds what the statute allows and whether it just needs some work to make sure that it's within the statute, what's allowed by statute. And that's my concern.
And my concern too, which I didn't mention, is in my commissioner role, when our director was a interim director and we were looking at hiring her for director. So very early on, I sat down with her and talked about, why are we constantly recertifying elections? Like, why can't we get it straight right away? And her response was, to me, like, that's the normal course. That's normally what you do. So for me, that was, okay, we have to do something here to correct this. This should not be the way. It shouldn't be that you post results and then 2 weeks later have to come back and recertify results.
Yeah, the normal course isn't always the right way. I do stand with my comment, though. I want to make, this board should never get in front of the legislature and do more than what the legislature has put into statute. And I just want to make sure that before we adopt rules, that they are within the guidelines of what the statute allows for. So that's my only comment. So Are there other comments from the, or questions from the board?
Yeah. A concern that was raised by the county election board superintendents that was sent to us was that the proposal, given the Thursday. I'm sorry, you're absolutely right. My apologies. You know, we did get some input from the county election board superintendents, made up of everyone in the state. And it's technical, but it's an important issue, is that, you know, by requiring the deadline as of Thursday at 3 p.m., you run counter to both the federal and the state law, which requires the processing and acceptance of provisional ballots until 5 p.m. on Friday. So that's an issue that we're going to have to deal with when it comes to your proposal. Sorry, I'm reading over the thing.
Yeah,
I want to let me go ahead and read it to you. The author of the proposed rule seems to be this is their words, not mine. Seems to be unaware that ballots can be returned and cured as well as processed and accept provisional ballots until 5 p.m. on the Friday after the election. Meeting prior to that to go over precinct results would potentially ignore legally cast ballots. We check to ensure a ballot has not been issued to the unique voter ID at the time we issue ballots, and routinely investigate small discrepancies prior to certification meetings. Also, ballots are counted at Election Day polling places, and the results of those ballots are tabulated and released on election night. Not counting those votes until the board meets would contradict with multiple code sections. So anyway, that's there.
And they're talking about ballots. They're
Yeah.
not talking about voters. The No Ink poll pad keeps a list of every voter that comes in. It's uploaded immediately to the Secretary of State, so your My Voter page could be updated. What you need on the ballot side, yeah, sure, you can count the ballots. That's what they're doing. But you've got to count the voters marked as well, which they're not doing. They're not reporting the voters marked. You can, in a primary, immediately on a poll pad, you can go and check how many Democrat voters have voted, and it lists their names, how many Republicans, and you can do a blanket list with both. And it's not contrary to a statute, because by 10 p.m. on the close of the polls, the day of the primary election, this is 21-2-421, they must report the number of ballots cast at the polls on Election Day, the number of ballots cast in advance voting, and the number of absentee ballots cast as well.
You would still have the provisional.
And the provisionals, you have UACAVA that might trickle in, but mainly those votes will trickle in, but they're not a lot. They're a very small number.
Yeah, I agree with you. The principle of what you're trying to do is make sure that before certification that you match ballots with voters who voted. I'm just trying to figure out the technicality here.
Yeah.
The technical aspects of the ballot.
And maybe, an exception for provisional
Yeah.
and UACAVA ballots that come in that need to be cured.
Yeah.
I almost think it might be a better procedure going forward for anybody who wants to have proposal for rules change to work beforehand with a member of the board to see what some concerns we might have, potential, and work through those before the meeting, and eliminate some of this.
Yeah, I worked with our board, or Vernetta Nuruddin is a Democrat who's a former longtime election board member.
Yeah.
And she withdrew her name from this.
And withdrew her name, yes. She wanted some tweaking of the language last minute. I haven't talked to her. I've been in D.C., so it was a whirlwind. I flew in this morning.
So I'm very concerned that there are suggestions that entire precincts should be eliminated from certification in this draft. It is.
If there's a discrepancy,
it violates federal law. It also violates state law because Section I says if any error or fraud is discovered, the superintendent shall compute and certify the votes justly, regardless of any fraudulent or erroneous returns presented to him or her, and shall report the facts to the appropriate district attorney for action. A proper venue for resolving discrepancies and fraud is an election contest in the court. It is not through the certification process. And federal law, 52 U.S.C. section 10307 lists as a prohibited fact, no person acting under color of law shall fail or refuse to permit any person to vote who is entitled to vote, or willfully fail or refuse to tabulate, count, and report such person's vote. That is a criminal act to refuse to certify valid votes. If there is a discrepancy of 2 votes in a precinct, and this rule, if you can't identify exactly what that discrepancy is, this rule would suggest that the entire precinct be disregarded and not counted for certification.
well, you wouldn't certify the entire election until everything's
If there are
investigated,
2
not
votes-
just one precinct.
And we're failing to certify the entire election means that you are discarding 500, 600,000 votes when there is a discrepancy of 2 that would not impact the outcome. Where there has been a discrepancy of 1 or 2 votes, we have seen election contests overturn those elections, and they have been run again. And that is the appropriate method of challenging even a handful of votes. It's been done in Georgia. It's been done. We had one election that was run 3 times, and it was appropriately overturned through the courts, not through the certification system. That is not what certification is about.
So my hope is to reel in the blatant Fulton County not running their elections correctly. In an absentee voting area, maybe if they have to account for discrepancies when they run the absentee ballots, it won't be a question that, oh, we accidentally double scanned 3,000 ballots. That's 3,000 votes that were possibly counted that could have been caught right there that night if they just matched the number of voters that they had marked off and the number of votes they scanned. Instead, we're 4 years later talking about this and trying to reconcile this. And 3,000 people were disenfranchised. My vote was probably disenfranchised because somebody else voted twice.
No one voted.
And it also says by state law
Ms. Thorne.
that temp workers should not be touching ballots. It says permanent workers.
I'm sorry, how does that relate to this petition?
It relates to this petition because Fulton County is using unqualified trained temp workers that are doing their counting and their tabulation as well, which leads to errors because temp workers come in, they come and go, they're hourly workers, and I feel like we need some kind of control over the process. There is no control over the process in the warehouse in Fulton County. That's why they had to recount the recount in November in a municipal election.
Mr. Chair. I like the idea of this rule and the premise that there's some basic ballot accounting that needs to occur with every election in every county in Georgia. Accounting rules must be followed. HAVA, when HAVA was written, Help America Vote Act, Harry Hursty was asked his opinion as an expert on how to design the requirements for ballot accounting, especially with electronic voting. And he used the principles that are used in banking. He used chain of custody, dual control, and an audit trail. So it's only reasonable and logical that we would have a rule that would outline these processes. And part of the canvas is to make sure the numbers are correct, that the voters that checked in equals the number of ballots cast equals the number of votes counted. It's just a simple mathematical problem, and it shouldn't be hard to solve. And it should be, and there's a reasonable amount of time. I know we have a short certification time, but certainly by Thursday, with accepting UOCAVA and provisional ballots that are due by Friday after an election, all the other vote totals, ballots cast, numbered voters should be available for review, for confirmation, and for correction. It's a great idea. And whether it's a small county or the largest county in the state. So, I don't think it's asking too much of a county to provide these, and nor do I think it's asking too much to have the canvas board, which should include the Board of Registration and Elections persons, to be a part of that canvas team. There must be a canvas team that's looking and checking and double checking and making sure that all of the numbers match. I'm not talking about fraud. I'm talking about basic ballot accounting, basic accounting. So I think this is a reasonable rule, and I would recommend that a rule such as this would, if it's voted on favorably, then it would go to Legislative Council for proper wording to put it in the right perspective as far as a legal rule that would be included for a state election board rule.
I would like to comment. In 2022, I had a conversation with Ryan Germany, and he told me that there are counties out there that do already do this. He explained that Richmond County was off by one voter in one ballot, and they were searching and searching because they wanted it to be perfect. I don't know if they ever found the one voter, but there are counties that do this. It's just really reeling in some of the counties that ignore trying to match up the number of voters with the number of ballots.
I think the legislature has really expressed its desire for certification at the county level to happen as quickly as possible. They moved up the deadline in SB 202, and they moved up the reconciliation deadline from 2 months to 1 month. The counties have been given by the legislature 1 month to provide that reconciliation on a precinct by precinct basis. To require it 2 days after the election is contrary to the legislative will that has been expressed in our laws.
Well, the documents I think that Commissioner Thorne or Ms. Thorne is talking about are documents that are already there at the close of the election. They're the numbered voter list. They're the numbers on the BMDs or the scanners for the number of ballots cast, and the totals from the memory cards for the votes counted. Those documents, that evidence, are already there. So it's not like they have to wait so many days to find that. They're produced already at the close of the polls.
What documents do you receive when you have to certify an election?
Well, maybe our Board of Elections members here could answer what they've received, because I haven't had to certify an election. But as a manager, I fill out ballot recap sheets with the number of voters who voted on every machine, the number of ballots I turned in, and on election day, I have to account if there's any discrepancy. And you fill out the provisional ballot recap sheet, so all that material is there, as well as it should be in the no-ink poll pads.
If there are folks who are on election boards present,
Would you like to
if maybe y'all want to say something?
You're speaking to your mic.
I'm sorry. You're absolutely right, and I do apologize. If there are members from the county election boards that are here that would like to comment on this, Mr. Chairman, I'd be more than happy to hear from them.
I would love to hear what documents you actually received before you have to certify an election.
It's an interesting time to be asking that. I'm Julie Adams. I'm a board member in Fulton County, Board of Registrations and Elections. I was sworn in February, right during the PPP election, and requested some documents. Basically, I wanted to know who voted, where they voted, and how many ballots were cast, as is in law for us to do before certification. I was denied that request. I have no special privileges, as I've been told. And I got a summary of the statement of votes cast, which is a not very detailed report. It's a Dominion, I believe it's a Dominion report. I also got a summary of the elections results, which does not tell me who voted where and when and how. It's a very non-specific form. And so in my opinion, it's very hard to certify when you're not following the law and knowing who voted, where they voted, and how many ballots were cast.
The Georgia Code says that the votes cast shall be provided in a statement of votes cast, SOVC, by precinct and by ballot type. Some counties do that and provide that, and it's an easy way to look at the numbers and see if total numbers do or don't match. Interestingly, there is an SOVC, a statement of votes cast, from election night in 2020, and there's also a statement of votes cast from the recount of election of November 2020 for Fulton County. Only 10% of the precincts had the same number of votes. 10%. So I've got a statement of votes cast on election night and a statement of votes cast on a recount. And 90% of the precincts have different numbers by precinct of total votes. Explain that.
Well, I think part of that is because votes cast and ballots cast are different. And our system, our election night system is not designed to report numbers of ballots cast. It will not report undervotes or blank ballots.
Well, I would hope the county would be using the same definition for reporting, for a whole report of statement of votes cast on this day, and then a month later a statement of votes cast on this day, unless they're changing the definitions.
Well, when you're talking about having a post-election reconciliation and you have ballot review panels that in fact cure discrepancies for hand-marked ballots, if it can't be read, that's why we have ballot review panels. And so that is just in general. But what the law allows is to compare numbers. The law does not call for comparing names and voters. It allows for numbers to be compared. That is precisely what 21-2-493 Section B says, that the superintendent shall compare the number of persons who voted in each precinct, and the number of ballots cast. It does not call for doing comparisons of lists of voters.
To the contrary, there's an enumerated or a numbered voter list that is required and produced at the end of voting on election day, and it does have name by name by name, and today it's kept in the no ink poll pad and can be produced by no ink, and it should be available, and is actually one of the documents that is to be retained by the superintendent and the clerk of the court. And it's not telling you what they voted for or who they voted for. It's simply a list of the name of the voters. And actually, that's produced for political parties on a daily basis.
Member Johnson, do you think that if the legislature wanted them to have that list, they would address that issue? Or, I mean, going back to my original concern, are we trying to do something that's outside the scope of what the statute states? And that's where I'm confused, is are we trying to do something outside the scope of what the statute states? And I'm always concerned about that. So I don't disagree with you that it exists. Right. I don't disagree that they need information. The question is what is allowed by statute. And that's why I think that I have some sympathy for what you're asking for. But I want to make sure that this board always follows the statute. So
I think it'd be fair. It would be fair to say that for certification, the Board of Elections would be provided the numbered voter list by totals, but that list should be available to anyone that requests it for comparison. And actually, the code says that list should be reviewed to prevent make sure names are not duplicated on that list, meaning that the list is true and accurate. I don't think a board would be looking through thousands and thousands of names before Friday or certification day, but it should be kept and available and put in a format that doesn't allow any changing of that list. There are famous cases of election irregularities where names were added to the bottom of the list. And so that snapshot of the numbered voter list should be made and set and not be allowed to change at the close of the polls on Election Day.
Yeah.
And one would hope that would create more transparency, but also problems with double voters or things like that, I think would be important.
And that list should be comparable to looking at the petition to vote, the application to vote, which now we're moving more and more electronically to electronic sort of applications and records. But that also should be reviewable. And voter certificate binder, the old-fashioned notebook that had the list of all those applications. You probably remember
Before
that,
the
Ms. Thorne.
digital poll pad.
Do we have
Right.
any other county election board members here who would like to say something? I have two guys up here standing, looking like they want to say something.
I think they're just tired of sitting.
Good morning. My name is David Hancock. I'm a board member of Gwinnett County. And I was been on the board about a year, so this is my first chance at certification. And I swore an oath to try to ensure that the elections were done accurately and fairly. And so when it came time to certify the election, we were given totals for a number of voters. Gwinnett County is a large county also, as you know, so we couldn't obviously go through and check everything. But I asked for some basic information. One of the things that happens on election night, we have 157 precincts, and they all bring in their data, and someone checks to make sure everything is in order. And I asked to see just the check-in sheets. I asked to see a lot of information, and it was kind of, I felt like it was a surprise to when I was asking for this, but I was trying to make sure that, to the best of my ability, before I certified that this was an accurate and a fair election, I wanted to at least give, I say, a cursory glance. I can't look at 650,000 voters, but at least do a little due diligence. And I was told that a lot of it wasn't available, and I could do an open records request to find it out. So I did open records requests. I did about 6 of them, and I got them over the next several days. But by the time the certification time to certify came up, I didn't have the information I felt just to get the basic information. So I voted not to certify, and I got a letter from the Democratic Party as well. And the interesting thing was, several days later, they found some more ballots. So we were called back in to recertify. And I asked, what is the point of certifying? If it's a ministerial task, if it's simply something that we come together and just say, yep, certify, why even do that? Why is it in the law that that's a step to be done before the election is finished? So those are
I'm
my
sorry, I'm stuck on an earlier comment you made. You asked for information from your elections division, and they told you to do an open records request, and you said on the board.
There's, yes, sir.
Okay.
And as a commissioner, I'm told to do open records request.
Okay.
And I was explained a legal reason, which kind of made sense. So, I mean, if you want to know it, I can tell you.
I'd love to hear that reason.
Yeah, if you want to know.
There's, well, okay, I don't want to take up much time, but there's two positions outlined in the Georgia law, basic positions. One is sometimes called the director, but it's called the supervisor of elections. One's called the superintendent of elections. If you have a large county, you generally have a board if it's authorized by the state legislature. And that board consists of multiple people, 3 to 5 people. Our board has 5 members. So our board functions as the superintendent. So in the law, it'll say the superintendent can do this, the superintendent can do that. I, as a member, am not the superintendent. It would require a majority of the board to vote to do something to be the superintendent. That was the explanation I was given. Which is not a horrible explanation, I'll admit. But Gwinnett County is very good, on the record, Gwinnett County, where they're very good as far as answering my request. The supervisor there will respond to emails on Sunday afternoon if I send them. They're very good and very open. I can go anywhere I want to. I'm allowed to go in early voting and election day and go to visit polls and precincts and, just make sure things are going smoothly. But in this case, it was difficult to get the information in time for me to have a good feeling about certifying.
So this is, canvassing and what you're talking about and what this rule pertains to is all described in the Election Assistance Commission report. Simply, you could go to that, and this is consistent with the EAC recommendation for canvassing. And what it is you're checking your work. So you have your election, you have people come in and vote, and they sign their names and do this and that, and you get these totals. And so then you canvass the election. You're checking your totals, you're checking your work to make sure that you come up with the right sum at the end of the night or the week. And so it's very easy. I would refer you to look to the EAC Commission for guidance
and that's
or more information.
Excellent point, Dr. Johnson. That is where I got some of my ideas from of what I wanted to see. The law is very clear. Here's what you have to be a registered voter. Here's how you have to open a polling place. Here's how you have to vote. Here's how you canvass, and then you certify. It's like the certification there seems like a step in the chain. I was watching a documentary on airplane crashes. First time this has probably been brought up in the state election board. And they talked about the fact that there's really not a single point that you can say this caused the crash. It's a chain. And if that chain is broken anywhere along there's that's what happens. If it's broken, then the crash doesn't occur. And the same thing with elections. If this chain is solid all the way to the end until the results are announced, then you have a valid election. But if at any point in there's a break in the chain, then there's questions about the election.
Let me ask this. If you were at your election headquarters as the returns were coming in, could you have seen those checklists when they
I
were
tried.
completed?
Not really. We've got a table. We'll have like maybe 8 or 9 staff members. Parking lot was backed up. I went out there and tried to comb. Poll workers are coming in trying to drop off their materials, and they waited sometimes for an hour and a half in the parking lot. And so they were coming in, and it was happening multiple stations at once. So I was able to stand in front of several. I saw several cases where it was only one poll worker. I brought the ballots in by myself, and I said that's not the way it should be done. But I don't know what happened at other locations when I was going there. Then those packets put together and they're whisked away back into the back. So it would be difficult with 157 precincts for me to look at them all as they were coming in.
Sure. But do you understand what the legislature has said is required for certification?
No.
Because the law does, the law is very clear. The legislature has written that showing the number of persons who voted in each precinct and the number of ballots cast. That is what the legislature has dictated the superintendent shall review for certification. And so the risk is using pretextual reasons to fail to certify when folks are not pleased with the results. That is my concern, is using excuses to fail to certify.
So you're saying we're dishonest by requiring this. We're using excuses as your words. So anybody who supports this is going to try to disenfranchise somebody. So you're thinking the negative of us. You're switching it, right? Is that correct?
That is my fear, that by allowing far beyond what the legislature has dictated should be the standards for certification, that as written by the legislature is simply not something that we have the authority to do.
You have to turn in the voters, the number of voters cast and the number of ballots cast, right? So we're just asking for that list on a precinct level. It's already written in the law. You just read it.
But it's also written in here that precincts shall not be included in certification if there's any discrepancy.
Correct. If you have more voters than ballots or more ballots than voters, you shouldn't certify.
A precinct of 5,000 voters, all of them should be disenfranchised.
Well, in a
for
precinct
one.
of 5,000 voters, you're probably going to have 1,000, election day. I have 4,000 voters in JC 13A and B. I had 150 voters. I can easily rectify where in the chain I lost a ballot, or maybe someone checked in and had to vote provisionally, so I printed the ballot because, Fulton County, we had to keep the polls open, and so you can't put them in the normal tabulators. So I have to account for every ballot. What we need it in every step of the election process. When you're processing absentee ballots, you should be processing them in batches, and you should be doing an audit right there. Okay, I had 100 voters checked, I have 100 ballots here. Okay, we're good. Let's do the next 100. There's no processes
This is
in
about
place, or it doesn't
certification.
force.
The rule is about certification.
And
And
this-
the rule would allow for entire precincts to be discarded.
Well, you'd prefer 3,000 extra voters to disenfranchise 3,000 voters 4 years later. Is that what you would prefer? Because they didn't do a check? They didn't check to see how many votes they scanned or double scanned that night? Yeah.
I'm sorry.
Wait a minute, there's one more. He hasn't spoken yet.
I know, I
don't
just
mean
want,
to take over.
I just want to make
I
a
just-
point on that. Based on the law, it is, if the numbers don't match, you need to investigate to make sure the numbers are right before you upload those results. So what Commissioner, or I don't know what to call, Ms. Thorne, what she's saying is that we would catch those problems beforehand. We're not talking about throwing out precincts. Honestly and truly, if the investigation was hard to find out why the numbers were wrong, a county might be late in certifying, but they'd be a whole lot closer to being correct and returning accurate results.
Ms. Thorne, I have no idea how the board will vote on this. I really don't. My personal opinion is that this rule needs a little bit more work on it to make sure that it fully follows the statute. And that it's just not ready for prime time yet. But that's one board member's opinion.
Mr. Jenkins, attorney.
To reply to the question from the board early on, what do
And your name, just.
Michael Heekin, Fulton County Board of Elections, what do we want to see? We're mindful of the fact it's a incredibly short time frame. It's measured in hours between close of polls and certification. So what we've asked for, and unsuccessfully asked for, are things like a ballot recap for the votes. In that you would see how many people applied to vote, how many people had ballots printed. I'm talking about DREs, the electronic, but there's similar. How many people applied to vote, how many people got ballots printed, how many were scanned, and how many hit the tape. A equals B equals C equals D. That exists at midnight when polls close, okay? So in other words, we got 4.5, 5 days to get that to the board. Okay, another thing that we've asked for unsuccessfully is chain of custody documents. Anybody who's been in business or has practiced criminal law or anything else or has dealt with Schedule I drugs or whatever knows what chain of custody is. In fact, I do too. This is my chain of custody from Fulton County Board of Elections for the tablet they gave me. Why did they make me sign a chain of custody? Because it's important to them that they don't lose that tablet is accounted for. So, but unfortunately, and by the way, the chain of custodies should be complete again by midnight on election day. But what we're seeing is that they're not complete, and it's taking them a week and a half to go back and get people to sign chains of custody that they didn't sign on night. That's fiction. That's a Potemkin village is what that is, because if the chain has been broken on election night, then we have problems. That doesn't mean we won't certify. Then we need, through common sense, we need to look at other things that would give us the level of comfort to certify. And by the way, I'm going to ask later on, I'm the last on the agenda tonight, sorry. But
don't say tonight.
Yeah. I'm going to ask that you consider defining what to certify the results of an election means, because neither the election code.
We'll get that one later.
Okay, I was just working the refs. Okay, thank you. Thanks very much. Any questions for me or no?
No. I share the chair's concerns, but I also share yours. And I'm not so sure if this rule is ready for prime time. Unfortunately, in talking with our attorney, with the Attorney General's office, that they basically have said to us that our choice is either to accept in total or reject in total your particular petition. That doesn't mean...
I believe that the petitioner can withdraw the petition also.
Well, they can withdraw. And we do have time before next certification takes place. We've got time. We've got multiple meetings set up. We've got one, I think, tentatively we're looking at in July, and then we've got another one in August, in October, to try to get this right. Because I do hear you in terms of there seems to be some inconsistencies in terms of what different counties allow board members to see before they certify. And, it would be good for the various board members to have a clear roadmap. There's definitely some concerns in terms of what can be legally done in terms of throwing out an entire precinct. But I do hear you in terms of trying to get it right. I had a delightful day yesterday listening to all that. So what I would like to see us do is to have 2 board members and someone such as yourself or someone else sort of try to come up with a rule that we can take back up in July, for instance, and see if we can, and working with the Attorney General's office if necessary, in terms of the legal issues, to try to, at the very least, have allow our county election board members know what they're going to get before they have to certify, and have the county's supervisor know clearly what they need to be giving to their board member prior to certification. If nothing else, that'll hopefully take care of a lot of those issues you're talking about in terms of discrepancies. I'm a lawyer, so I love lawsuits, and I've had to defend candidates in election disputes, but I don't mind having a few less cases if we can satisfy that before that takes place. So, like I said, unfortunately, I'm going to end up having to say no to this petition, but I'm going to do so with the understanding that that at the same time that we put together a group. And top of my head, I'm thinking about our two most vocal people on this issue. That would be you and Dr. Johnston.
Anybody not named John Verveer?
Anybody not named John Verveer, to sort of work together along with someone like yourself to see whether or not we can come up with at a minimum, come up with, and also take into account other county election boards members. You know, we've got a pretty good organization, for instance, a statewide organization of superintendents. On both sides of the political party, they could probably give some input to this issue too. So that would be my recommendation. And I'm going to ask you if you're willing to withdraw your petition, with the understanding that we will do a study group that will work with you to try to present a proposed rule for the next July.
Mr. Chair,
Yes.
a couple of points. First, I think it would be appropriate to ensure any board members, any county board members here, that they really should have full access to documents in their county election office. There should be no reason why they have any limitation of access to look at documents and to supervise the conduct of elections, which is what they're supposed to do. That includes paper documents or electronic documents, the election management server, results tally reporting. If anyone should be able to see the votes that are being totaled on the election management server, it should be the county board member. So that's one point. The other point is looking at Georgia Code 21-493, it does say that one should have the number of persons who voted, the total number of ballots cast, but then it goes on to say no votes shall be recorded from a precinct if there's a discrepancy until the investigation shall be had. So it's still very clear. We're talking about number of persons who voted, number of ballots cast, and votes counted. It's 1, 2, 3. And that's by precinct, and it's part of the canvas. It's part of canvassing the election. So you get all the numbers, and then you check your work. You get all the numbers, and you check your work. So, I don't think there's really should be any question about that. And the other comment is as far as talking about whether to accept this petition for a rule, is it kind of sounds like you're saying a citizen could not provide a petition to really be considered.
I'm not saying that at all. I'm just saying this particular petition. I didn't say that.
Okay, you're not saying that about any petition.
No, I'm just saying this petition needs more work. The issue, I think, is legitimate. Just the petition needs more work before I think we can move forward. No, please, you're out there. I like getting petitions. I like getting proposed rules. It allows us to think about things. No, that's not even remotely what I'm saying. I'm saying this particular rule needs more work, and I want to see it taking place because I do think some legitimate issues have been raised.
Ms. Thorne, at this point, we can either proceed with a motion to accept or deny this petition, or you have the opportunity to withdraw this for further work and resubmit it for our proposed July meeting.
Well, if you vote on it now and you reject it, does that forbid me from going forward and reworking it? and bring it forward again.
No, but I just want to make sure you understand why I'm going to vote no, it's because I don't think you raised some legitimate points, because I think you have. It's just I want to make sure that you understood that. It's your option, ma'am. I'm going to do what you asked. But I'm going to also tell you that I think that we need to look at what board members should be able to see and get before certification. And that should be a matter of public record too, so that the public gets to see within that timely time period in order for transparency to take place.
I mean, for transparency, it'd be great if everybody posted it online for everybody to see. If we want to be fully transparent.
Yeah.
But I think I'll leave it for you guys to vote down.
Okay.
But I'll be happy to work with any of you on the board that would like to work on it and outline it and make it clear if it doesn't pass. And I appreciate your time. Thank you.
Was there any further questions from the board? The chair will entertain a motion. On petition for rule changes pursuant to Georgia Regs 183-1-1-.01 submitted by Bridget Thorne.
Mr. Chair.
And I believe the rule, or proposed rule in question is Rule 183-1-12.12.1, pre-certification reconciliation of number of ballots to number of voters. The chair will entertain a motion.
Mr. Chairman, I would move to reject sorry guys, you're right. Move to reject the proposed rule, and at the same time have the chair appoint a subcommittee of 2 members of the board, and those 2 members can also name individuals off the board to assist in coming up with a proposed rule to be considered at the next meeting.
We have a motion to reject the proposed rule and for the chair to appoint 2 members to work with the petitioner to come up with a alternate rule to being presented at the next meeting. Is there a second?
Second.
We have a motion and a second. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposition? Hearing no opposition, the motion passes 4-0. The next item on the agenda is a petition for amendment of State Election Board rule presented by Sally Grubbs. Is Ms. Grubbs here?
She is.
Good morning, now afternoon. My name is Sally Grubbs. I'm the chairwoman of the Cobb County GOP, and I'm also an executive committee officer for the Georgia GOP, the over 80,000 chair. And the rule that I presented to the board, I originally presented in November. Mr. Mashburn sent me an email because at that time I did not have it verified. I did resubmit it to this current board verified. This is concerning State Election Board rule in amendment to 183-1-14.02. It is a proposed amendment to add paragraphs 18 and 19. The proposed amendment provides for documentation of delivery and casting of all absentee ballots except by United States Postal Service and Uocava cast ballots. The amendment also requires video surveillance and recording of all drop boxes and clarification that the recording is an election document to be retained as required by law, which we know can already be accomplished due to change in law previously. So the rule states that for advance voting, to paragraph 18, any absentee ballot drop box or any location other than the United States Postal Service that receives absentee ballot shall require an absentee ballot form with written documentation, including absentee ballot elector's name, signature, and photo ID of the person delivering the absentee ballot, and approval relation to the elector's name on the absentee ballot. An absentee ballot form provided by the Secretary of State shall be completed by the registrar, clerk, deputy, or election official. The form shall serve as written record of the name of the elector, the name of the person delivering the absentee ballot, the relation to the voter, signature of the person depositing the ballot, and the type of ID of the person delivering the absentee ballot. The absentee ballot form shall be returned with the absentee ballots and chain of custody forms to the superintendent. Any ballot not included on the record, absentee ballot form, or any ballot delivered without a signed chain of custody shall be considered a provisional absentee ballot. The superintendent shall notify any elector with a provisional ballot immediately and provide information and instructions on how to cure the provisional absentee ballot. 19, at the close of polls each day during early voting and after the last voter has cast his or her ballot, the poll official shall initiate video surveillance and recording of the polling place. Such surveillance shall include visual recording of the drop box if there is one located at that site. Any drop box that is not under constant and direct surveillance shall be locked or removed and prohibited from use. Video surveillance may be live streamed, but must be recorded and will be considered part of the election documents and retained as provided in Code Section 21-2-390. Similar to Ms. Thorne's rule, it is about chain of custody. The justification for the rule, it is incumbent upon you, the State Election Board, to take actions to secure the elections process and give voters confidence by evidencing your commitment to ballot security. We do place our trust in you, all of you members, to stand for electors and ensuring that legal ballots are counted and illegal ballots are dealt with in accordance with the law. While the burden is heavy, there are steps you can take to give voters confidence and to stop voter suppression by not allowing the dilution of votes by allowing illegally cast ballots. I'll interject here that if you look at Gwinnett County, Cobb County, and Fulton County, you're looking at the majority of voters in the state of Georgia when you add all of these metro counties together. And what you're doing, not you, but what the legislature, what all of the people who are in any position of authority to have any effect on elections is doing when you are not allowing proper chain of custody, such as with Ms. Thorne's rule or with this rule, is you are allowing voter suppression to occur by diluting the votes of the rest of the voters in the state. These people in smaller counties who are following the rules and doing the returns like they should, their votes are being suppressed by not properly accounting. It's the same thing with advance voting. Part of the reason for this rule came up in Cobb County, where we had situations that now they have decided to allow libraries as government buildings to be repositories for unverified absentee ballots. And so that's part of my commentary on that. Justification for the proposed amendment is that surveillance was previously authorized and evidenced many unauthorized drops of absentee ballots in many locations across Georgia. There have been locations authorized for ballot delivery in Cobb County, for example. However, it was a government-owned building, a library, and had deputized individuals receiving ballots that were not checking identification and validating the relationship to the voter. This broke chain of custody and did not guarantee that the person dropping the ballot was, in fact, related to the voter or authorized by the voter to deliver the ballot as required by law. It is imperative that voters have confidence in the delivery of their absentee ballots, and it is incumbent upon the individuals receiving the ballots that they are legally processing the ballots and providing for the necessary security for the receipt and transmittal. By way of further example, there was an instance in the 2022 election that ballots were delivered and dropped into the tax committee. Y'all are not going to believe this, but it's true. I had to deal with it. They were delivered into the tax commissioner's payment drop box and were accepted as legally cast ballots, although there was no chain of custody. So this happened in East Cobb. There's the tax commissioner's office where you receive tax payments. There was a box there to receive tax payments, and people were putting their absentee ballots in the box. There was no chain of custody. There was no video surveillance. The tax commissioner's office opened their box at the end of the day, and they took those absentee ballots, and they were just accepted by the Board of Elections.
I know that that is a concern with other counties too.
Very much so. Furthermore, this would impede the ability for bad actors to further erode the integrity of Georgia elections and further eroding the trust in the electoral process in Georgia. Every in-person voters cast ballot as received in person. This should be no different for absentee ballots. This amendment provides no undue burden on the election workers nor the ballot deliverer. Additionally, this meets the same requirement as an in-person voter. For all of the above reasons, I respectfully request that you approve this rule proposal. And I do want to, I should have said this in the beginning, but as volunteers in your position, I'm fully cognizant of how much time, effort, and energy that you put into doing this volunteer position. But I can think of no greater burden, honestly, that you have in addressing some of these rule proposals and changes. And when you talk about the legislature, I hear what you're saying. But it's, as I was sitting here listening to Ms. Thorne's proposal, I think if the legislature was afraid of you all overstepping your boundary and authority, they would have representatives in the room to indicate such. And as we all know, I think it should be a requirement for any legislator to run for office in the state of Georgia that they have to actually work an election. Because we have all of these rules being proposed, legislation being proposed, and half these people don't know who No Ink is. They have no idea what a BMD is. And so I thank you for educating yourselves on that, being sensitive to it, and I appreciate your bold leadership in looking at these rules to put forth meaningful election changes by promulgating this proposed rule. So thank you.
I want to tell you, I have it on good word that the legislature knows exactly what's happening in this meeting. So,
are there any legislative members here in the room today? Would love to recognize you if you are.
Questions, comments from the board? I'll start off. To me, there's a difference between somebody who walks in and hands a ballot off to a poll worker. And I'm trying to find the difference in my own mind between a ballot box and a mailbox. Gwinnett County, my home county, there's 7 maybe ballot boxes, 6, 7, I think it's 1 per 100,000 people, voters, and there's hundreds of mailboxes. And so in my mind, I'm trying to reconcile what the difference is, somebody walking into the U.S. Post Office and dropping a ballot off, or just going to a ballot box and dropping it off, And when you have hundreds of U.S. Post Offices, I'm not sure why we need ballot boxes, frankly.
You know what? That is an excellent point, and I 100% agree with you, and I think we should get rid of all drop boxes. We are in agreement.
And I know it's required by by law. I understand. I'm just, my own mind, I'm trying to make that understanding why they're needed. And that's a legislative issue, not a state board issue. We're not going to get in front of the legislature on that. But I'm trying to decide why there should be a difference between U.S. Post Office and a ballot box, and why we should record one but not the other, and why we should have requirements for one but not the other, when it's essentially the same thing. You're just dropping off a ballot into a box someplace. When you drop it off and hand it to a person, I can make the argument that that's different, and that there should be some rules. And in fact, I've had discussions with some members of the board about that and tightening up those procedures somewhat when it's hand delivered. And so this has been a concern of the board, and Dr. Johnson and I have talked about this and extensively. So I sympathize with what you're trying to do here. with part of what you're trying to do. There's still some questions in my mind about the whole ballot box.
Well, to answer your question, perhaps it's because there is surveillance at United States postal facilities. And perhaps it is because there have been people caught dumping off hundreds and hundreds of ballots at United States postal facilities, and through open records requests, that's been discovered. And so I think at the very minimum, I mean, I'm going to be completely honest with you and tell you it's very difficult to sit here and to watch the proceedings yesterday and to be trying to be part of the constructive process of participating in government when we are talking about our most sacred right as an American citizen, is our vote. So the same way you're saying, and I understand your argument, if we've got the mail and we send things through the mail, then why should we treat drop boxes any different? Well, to begin with, we shouldn't have drop boxes. To begin with, we shouldn't have 19 days of early voting or 18 days of early voting in the state of Georgia. To begin with, there are a lot of problems with our elections, and this is incredibly personally frustrating for me, because we're sitting here asking you to secure our elections. And at every turn, it's, oh, we might not ought to touch that because the legislature might get upset. Well, let the legislature be bold, make some bold decisions, secure our votes, listen to the people, because after all, the people, they only have a certain choice in electing legislators. Sometimes we can only deal with the hand that we're dealt with. But right now, you're in this position, this volunteer, unpaid, highly agitated position, listening to people scream at you, and I sympathize. I watched the meeting online yesterday, and I understand what y'all go through. But here we are trying to offer constructive things to give the people of Georgia a voice, and we are smacked down every time we turn around. I can think of no better hero and example of fighting for our elections than two women in this room, and that's Bridget Thorne and Janice Johnston. And I see them get shut down all the time. And I probably ought to keep my mouth shut because I do have this rule proposal before you, but I can't help it. You have got to do something. And, just shuffling it off to the AG's office, I mean, you're still hearing cases from 2020. Does that not scream that there's something wrong with this process? So I am asking you, show some goodwill. At least treat absentee ballots the same as an in-person voter. That's not going to kill anybody. If someone comes into a library to deposit their ballot with a worker, which is also not a poll, I will say that, you also are not appreciating the disadvantage that some of our Board of Election members are under in Fulton, in DeKalb, in Cobb County, in Gwinnett County. It is 4-1 in Cobb County. There's one Republican member, and she has also asked for the same documents that she should be given to be able to certify. And I don't know, I want you to appreciate the fact that when people say certify an election, they are ascribing their name to the validity of that election. And that means something to people. When they take an oath of office and they say, I swear to abide by the terms of the Constitution, that actually means something to them. And so you are putting, I'm sorry I'm speaking to Bridget's rule, but you are putting people's personal integrity and character in jeopardy when you are making them certify elections that are not correct, that they can't verify for themselves. That's saying sign off on this mortgage for $1 million and don't know what your source of funds are. It could be coming from Russia. Who knows?
I understand, and that's...
I know it's a separate issue, and I'm sorry. I apologize for that.
Let's deal with your proposed rule at hand.
I agree. I apologize. I told you.
I understand. You're passionate, and we appreciate your passion on that. But I want to get back to this, and I hear you about the ballot boxes, but there are still a lot of blue boxes out there, I think, that people can walk up to without having to go inside a post office and video recorded, And so that's what my concern is. Why would we treat these any different?
Well, there's also a specific way of handling absentee ballots with the United States Postal Service. So you've also got that issue. You have the issue when there's return mail, how that is dealt with local boards of election, and that kind of thing. There are provisions, there are federal provisions on handling absentee ballots with the United States Postal Service, but in the case of a drop box, you're just saying, bring them on, boys. That's what you're saying. You're saying, you know, give me all your tired, your poor, your hungry fake ballots, and let's put them in this box, and then let's not have a chain of custody on accounting for those, is what you're saying.
No, I haven't said anything.
Not you, but not you personally. I promise I'm trying to be on my best behavior.
So am I.
But there are other provisions for federally handling ballots through the United, because that is a federal situation. What you're talking about is, I'm repeating myself from December of 2020. This is the state of Georgia. And these are state of Georgia rules and regulations. And this is not something that is unreasonable. This is not something that is contrary to current law. This is not something that the legislature, if they are watching, is going to come back and smack you around for. This is just very common sense chain of custody issues.
The chair would love to hear the opinions of some other board members.
Mr. Chair, looking at this proposal, I would like to note that it says ballot drop box or any location other than USPS.
Correct.
So there are many routes today for return of absentee ballots. It can be the election office, it can be the drop boxes, and in some counties it may be early voting sites without drop boxes, or any number of places. So I think it would be a prudent thing to reestablish sort of the chain of custody when that absentee ballot is brought to anything other than the USPS to reconnect and ask that the person, the voter that's bringing their ballot, to simply say, hey, are you the owner of that ballot, and can you kindly show me some ID? That's what we ask when somebody comes in to vote. Show me your ID so you can get a ballot. No different, really. The difference with USPS and drop boxes is USPS falls under federal law. So if there are any irregularities, there's a little bit of an onus that somebody might be violating federal law too. So there's a difference. And drop boxes were actually brought into Georgia for the pandemic. The whole premise of bringing drop boxes to the state was because we had a pandemic, and we did not know how serious the viral pandemic was, and we wanted to provide an alternative for people to vote without having to get closer than 6 feet to someone else, or maybe pick up the virus and contract COVID-19. So there's really no need from a pandemic perspective to have drop boxes anymore. We realized that we had an issue when they were put outside the polling places with security, and the legislator brought them into the polling place. So now you're asking a person to bring an absentee ballot into a polling place where they could simply turn around and vote in person. So if they're handicapped or disabled, then certainly they can ask their next of kin relative or one of the 14 designated appropriate persons to take that ballot and take it to the post office, and you don't even have to pay for postage. That's protected with our laws. So why somebody would bring it to the polling place when they couldn't just drop it off to a closer mailbox, I don't know. So I think this is a reasonable thing to request. But if we are going to continue with drop boxes, then I think video surveillance of the drop box, and actually video surveillance of early voting sites at night during the early voting period is a fair thing to ask for also. When voters are gone and the lights are turned off, sometimes we find that those early voting sites aren't as secure as we thought they were, and doors are left unlocked, or people find their way in. You can walk through St. Philip's Cathedral and see voting machines all during the early voting period, and they're not secure. We just assume people are going to not bother them during the early voting period. So anyway, I think this is a fair petition.
You're recognized, please.
I appreciate what you're trying to do here, and I think there may be two separate issues that are being conflated, which is ballots being delivered in person to additional registration sites versus drop boxes, because the former is authorized under statute, but there is absolutely no detail provided in statute, and that is ripe for rulemaking. The legislature has made a policy choice to allow drop boxes, a limited number, and they have written very specific instructions on how they should be overseen. So they're not video surveillance, they're overseen by a person, and very specific chain of custody requirements for how those ballots are collected and accounted for and taken to election headquarters. I believe that this rule is applied to drop boxes extends far beyond our authority as a board. I just don't think we have the legal authority to add additional requirements beyond the very specific requirements that the legislature has passed and passed under SB 202. While it was an emergency measure in 2020, the legislature debated it and they decided, and there were even contemplations several times to remove drop boxes entirely, and they have made the affirmative decision to maintain them and to allow voters to have that option. And we can't go beyond what the legislature has dictated for use of those drop boxes, in my view.
Well, I find that that's a good point with dealing with drop boxes, but actually the statute says that they shall be under constant surveillance. Constant surveillance. So that doesn't mean just while the poll's open. Constant surveillance means 24 hours a day, as long as they're there. So, so it's our duty to make sure that we provide proper, constant surveillance of drop boxes while we have them in our elections. The other thing is, the issue is not just the drop box, but it's actually the return of the absentee ballot that we're talking about. So the drop box is just a metal box, but I think what Ms. Grubbs is speaking to is the return of the absentee ballot and the security of such, and the reestablishment of the chain of custody of the ballot.
That's right. And if I might add, I mean, as far as showing identification, you know, I can't go get NyQuil without showing my ID. Just to return a ballot to show ID and showing a relation is something that's well within the law. And you are given the authority to promulgate rules. I mean, that's part of the purpose of this board. And I really don't understand why anyone would have any issue further securing people's right to vote. It also protects the voters and the electors. So that's
my only problem with this rule is adding the documentation that you're requiring for drop boxes. I don't mind having them under surveillance. I don't mind the video. I don't mind any of that necessarily. But having a voter bring in and put a vote in a drop box and have them fill out the documentation associated with that, that bothers me, because I still can't differentiate in my mind the difference between a drop box and a blue box sitting on the corner somewhere. We don't have to do that. Okay, they're both surveilled. The one on the corner probably isn't, but I can't differentiate between those in my mind. And so I don't see the need for the documentation for somebody just walking in, putting in the drop box. And you add security to it because now you've got it on video. So if somebody brings in an armload of ballots and throws them in there, you're going to see that, you know? And somebody can file a complaint and we can investigate it and we can do all of that like we are doing other complaints. But that particular first line where you add drop box is where, you know, for the documentation is my problem with this rule.
Could your issue be resolved if on the, sorry.
We're
I'm
just
sorry,
going to have
guys.
to leave your chair up.
I know that, a bad habit, and that's right. It basically gives me somebody to talk to every once in a while. Could your issue be resolved by a line on the envelope that gets dropped into the drop box, in which the person who drops it has to certify who they are? Because, right, I don't believe, I'm asking you that.
I mean, I watch all your meetings.
Yeah, I'm asking.
And I am for whatever will get us closer
Yeah.
to the situation. I mean, I watched, as I was observing a drop-off location in South Cobb in 2022, this woman come in, and when posed by the election worker, now keep in mind, one of the Board of Election members was highly involved in developing their new process. See,
Sure.
that's what's so difficult to hear, because these boards of elections will come up with creative ways to get around legislation. They think outside the box to get around the legislation. That's why the whole library thing came up. And so they work really hard to figure out how to get people to drop off these ballots that may or may not be valid. And I've heard all the cases of the people, in particularly the vulnerable voters, who have their ballots carried, that then you can't go back. You know, you go back a year or two later. My mother's 96. She's in a nursing home at present. And, you know, I'm scared to death that somebody's going to go in and get her to vote a ballot. And then, you know, in a year or two or three, whenever, if something were to happen and there was a case or an issue, that information's gone. Those people don't work there anymore, and my mother's dead. And there is no justice when it comes to holding people accountable. So I find it a little bit bizarre to me that we want less accountability. I mean, if I have to sign a piece of paper, show my driver's license to get some, you know, Advil Plus or whatever, why is it so outside the realm of possibility for someone to actually show their ID and have that information as part of the chain of custody? I mean, chain of custody for our most precious gift that we have been given by this republic is being trampled on in this country, and specifically in the state of Georgia, into dust. And so I feel like it's this fight against accountability. If anybody was in a corporation and fought against that accountability, they'd be fired. They would not have a job. So I'm trying to reconcile that in my brain.
I understand. But I did have a specific question, and that was.
Look, something is better than nothing.
Yeah.
But I did submit the rule back in November, and I haven't discussed it with anyone since that time. I am always open to suggestions on how to make something better. I'm not here because I want to give you grief. I'm not here. I know it might not feel that way, Mr. Favere, but I'm here because we have a broken election system in Georgia, and unfortunately, or fortunately, you have been placed into authority by God to help fix that and to give all Georgians a fair shake. And right now, that is not happening. And this proposed rule would help a little bit in giving Georgians more of a fair shake. And so I hear what you're saying, Mr. Chairman.
I'm just trying to think here.
You know, as far as the Postal Service, they are two horses of different colors. I'm in agreement with you. Let's ditch the drop boxes, and I wish you did have that authority, but unfortunately I do believe that resides with the legislature, who isn't here today. I agree with you. However, there are federal regulations that govern that. We're talking about the state of Georgia, and we're talking about something that is within your power. This is within your authority. And I don't see how making our elections more secure is a bad thing.
Any other questions from the board? Member Gonzalez?
I would say further that when absentee ballots are given to another person to deliver or deposit or return, you know, that's basically a proxy, and you're just confirming the proper person that is a proxy for for
Absolutely.
that returned ballot. If it was the voter returning the ballot, I would instruct every poll clerk, precinct clerk, to say thank you very much. I mean, good customer service. Thank you for bringing, thank you for voting, and thank you for bringing your own ballot in. And when I worked in the elections, when I asked for ID, everyone has ID, and they're glad to show you. And when I go to a store and show ID, and they actually check my ID for something I'm getting ready to charge, I thank that person for making sure that the credit card I give them has my ID associated with it, so that I'm not being taken advantage of. So I appreciate that carefulness and checking.
I do too.
Make a brief comment?
If Ms. Grubbs approves it.
The speaker recognizes the gentleman to my right from Gwinnett County.
Thank you. We, as a board member of Gwinnett County, we just voted to accept absentee ballots at any open polling location and early voting, even if without a drop box. I tried to make the point that this sort of subverted what the state law appeared to indicate, that there would be one drop box per 100,000 people, by allowing essentially an unlimited number of drop boxes. So I tried to make an amendment that at least at the places where there was no drop box, the person dropping off the ballot would have to simply sign a form that said their name and the number of ballots they're dropping off, and then sign essentially an affidavit agreeing with the rules that are required by the state, the 14 people that you can drop off ballots for. And that was voted down in the, actually, the chairman refused to even call for a second on my amendment. So we would appreciate guidance and help on that, and I think that'd be an important thing. And just another point, even if it's not done correctly, you're saying the difference between the post office and the drop box, I've heard that argument several times. If it's not done correctly at the post office, that doesn't mean we can not do it correctly and when we have control over the state. So just because it's not 100% right at the post office, we can make it 100% or better at the state level. So that's all I had to say.
And that's, to his point, that's absolutely correct. Look at the early voting numbers for this primary election. They are paltry. People are disengaging at record numbers because people in authority are not holding people accountable, and they are not leveling the playing field. And at the end of the day, that's reflective on leadership. And I'm asking you, as the State Board of Elections, to lead on election integrity, lead on fairness in our elections, lead on accountability, and lead on integrity, because we have not had it from our Secretary of State's office. We see the reality of what's gone on in these elections, and yet we're subjected to the press releases that say, oh, we've done this. And I actually heard bragging that Georgia had the most days of early voting. Early voting does not equate to fair elections. So I'm just asking you to please lead on hearing a reasonable rule that is fair across the board, that does not put an undue burden on election workers, that, and to his point, just because somebody else doesn't, that if they don't do it right, doesn't mean we don't have to do it right too. We can step up our game, and it's up to you to step up the game.
Like I said, in my last comment is I agree with almost the entirety of your rule, with the exception of drop boxes, which I think exceeds the scope of what is in statute for us to do with the drop boxes. That's require documentation when somebody drops it off there. The rest of it I have no issue with. So.
But you have local boards who are changing a definition of a drop box, just so you know. Just like he said, in Gwinnett County and Cobb County, they are making these virtual drop boxes by allowing people to just drop them off wherever.
But No, that's different. When I'm talking about drop box, I'm talking about the blue box or the drop box where they actually insert the ballots. They're designating additional places where you can drop off a ballot to an individual, and your rule addresses that
Right.
for documentation. And as I have no problem with that. It's just the physical act of putting it in the box, to me, I can't differentiate that from.
Being under surveillance, just so I understand.
I'm okay with the surveillance.
Okay.
It's just, but requiring documentation for dropping it in the box itself, I have an issue with differentiating that between dropping it in a mailbox someplace.
If that gives you heartburn, I will give you my pen, you mark that point out, and you approve the rest of the rule.
I have this pen that was given to me by the governor when he,
I'm sure it's a much better pen than mine.
when I am honored to have gotten this job.
Just a point of clarification as far as surveillance. There's not video surveillance of the drop box during voting.
Correct.
Because of the privacy issue or alleged privacy issue, because it may be pointed somewhere else where a voter might be.
Well, because we don't have BMD
visualized.
security privacy, so that would be a reasonable statement for sure.
So there's not, constant surveillance is, I guess, might be defined as it currently occurs, is just that it's in a polling place. And so that's how it's being interpreted right now. But the documentation for who's returning that ballot is, that's a very important thing for the return of that absentee ballot, and establishing that that person is indeed the voter or a proper person, an authorized person to return an absentee ballot.
And also, too, on the U.S. Postal Service issue, while that's not the paradigm of, the panacea of voting returns of ballots either, because I grew up in the time where we didn't have absentee ballots unless you had a doctor's excuse or you had some kind of other reason to vote absentee. But United States Postal Service delivery, there are postmarks, so it came through that system. So I'll hush.
Any other comments from the board? Any other questions from the board? The chair will.
Let me ask you
this. Is it appropriate for us to make alterations to the proposed rule?
There's a
I'm kinda
dispute on
new at
that, but
this
I'd like to weigh in on yes, and then let's see if somebody wants to object to us after we do so. If we want to try to make, if there's some key but small tweaks to it, I think some rules require more handiwork, like the last one. But if I understand you correctly, for instance, your concern regarding the sign-in would be somewhat easy to fix in terms of any absentee ballot drop location other than the U.S. Postal Service or an authorized drop box under Georgia law, and then go on from there. I think you can pretty much get that one taken care of. And then I think, Dr. Johnson, you had a concern about something with the surveillance, or did I misunderstand?
Well, there's not video surveillance of drop boxes in the polling place during
business
voting.
hours, yeah.
But there is visual surveillance. I mean, they're in a location where people can see them, right?
They should all be in the
it's
polling
required.
place where the voting machines are.
And poll watchers
And
can.
visually, yes,
Yeah.
in sight.
So basically, then you're fine with 19 as written. I just want to make sure.
As this proposal?
Yeah.
I'm fine with this, and actually part of the rulemaking is this would go to Ledge Council and to the proper committees and assigned persons for review anyway, so that there's an opportunity, if there's an objection, a legal objection or amendments that are suggested, then those could occur during that process. So this could be brought back, it could go through the process and then be brought back next month for approving the rule as amended, and then it's posted a notice of filing, where it's officially, officially filed rule for 30-day comment.
Yeah.
I am so happy we don't conduct business in the real world that way.
My suggestion, yeah.
I'm trying to bring you along, but you just won't listen.
Yeah. My suggestion would be similar to some county election boards who don't want to sign off something blind. I don't necessarily want to sign off on a board, on a rule blind, hoping that somebody else will fix it. And so if we are to do anything today, I would recommend that we make the tweaks that the chair, for instance, has suggested regarding differentiating between drop boxes and other locations. And if we're going to move forward, make that differentiation, and then send it out for all the other people to take a look at.
And that does give the legislator a chance to, if they want to enforce it on drop boxes, they can make that change when they.
Then we can.
I would suggest
take
that
issue
that
again.
we send it as is, and if they don't like the Dropbox provision, for them to amend that and remove that.
Well, keep in mind, I have the chair and some other folks who are concerned about the drop box. So I'm trying to move something forward here.
I'm trying to move it forward too.
Okay.
You know.
So just approve it and then let it come back rejected if legislative council has an issue with it. Would that be appropriate, Dr. Johnston?
All right.
My recommendation. Go ahead, Mr. Chairman.
Yeah.
I'm not sure it'll get approved without alterations.
Let's give it a go.
Without alterations to it.
Okay.
Let's give it a shot.
And
Make your recommendation.
The chair is going to exercise its right to make a motion. The chair moves that this rule be adopted with the following change. That on line 1 of section 18, the words drop box or any are taken out, and the words with the exception of drop boxes is inserted in that place.
Or other than the United States Postal Service, can I recommend, or authorize drop box under Georgia law?
Okay.
That way we can move forward, and then we can have a further discussion down the road.
Do you have that down, Alexandra?
Would that cover a county being creative and calling something a drop box, and it really is not what we consider an approved drop box?
But isn't drop box defined under Georgia law? It's already
Very
defined. If
Very-
somebody's trying to get around it, they're getting around the definition of a drop box, which is under Georgia statute.
Okay.
That's why I put in there.
Official.
As I can use, as authorized, an authorized drop box under Georgia law. That's why I put that in there.
Okay.
To have that definition.
The Attorney General would like to weigh in on this, or Attorney General's office.
Can you make sure that this is on?
Oh, yeah, of course.
Russ, we should be able to hear you now.
All right. There has been a motion, and John, was your motion seconded?
It has not been seconded yet.
Okay. You had the phrasing of your motion needs to be altered. You said, I move that we adopt this rule. That is not the correct posture that you are in at this juncture procedurally. You have to move to initiate rulemaking proceedings. The adoption is significantly far into the future. You have to get all your ducks in a row with the promulgation of a rule, most of which the statute explicitly says you must exactly comply with. There is no substantial compliance with the vast majority of APA rulemaking. So you are moving, you would need to move to initiate rulemaking along the lines of whatever text the board so chooses. But you are not adopting anything today.
I hereby, let me make sure I got it right. I hereby move to initiate rulemaking
Proceeding.
of the proposed petition as amended. Is that right?
That would work.
Is that process significantly longer than withdrawing the petition and resubmitting it in July with changed
I don't think so.
wording?
It would probably work on the same timeline unless you discover additional errors or conflicts with federal law that would need to be resolved, and then you would have to start over. Every time you tinker, you have to start over. It's a return to go, start off on space 0 and begin the process over again. So it may be cleaner to initiate the process ab initio, where the board is making a first crack at the draft of the language instead of trying to alter a provision that you haven't previously had board input into. I am just flagging for the board any subsequent change to a rule after you begin the rulemaking process requires you to start over again at the beginning.
So the changes will need to be made now.
You know the language? You have the language written down?
Yeah. Russ?
I withdraw my motion.
All right, let me try this. I hereby move to initiate rulemaking of the proposed petition as amended as follows. On line 1, strike box or any. And on line 2, let me start by saying other than the United States Postal Service or authorized and defined drop box under Georgia law. I think that would take care of your concerns, Mr. Chairman.
Yes. We have a motion from Member Lindsay to revise and initiate rulemaking as stated by Member Lindsay. Do we have a second?
Second.
We have a motion and a second. Any discussion by the board?
Can I clarify that paragraph 19 would require video surveillance after hours of any location that any early voting location? Or is it any early voting location that accepts absentee ballots delivered in person? How would this operate now? Because it does not apply to drop boxes.
Let me ask the author, was it your intention to have the surveillance of drop boxes during after hours?
Correct, as long as active voting is not going on.
Yeah, hold on. Thank you. I just want to make sure I understood your point.
Yeah, because it says after the last voter has cast his or her ballot. So basically, at the close of business, so that, I mean, you have a drop box here, we're conducting business, everybody can observe the drop box. We go home at night, flip off the light switch that we have it under video surveillance. And I think the key there too is to also have the retention of that information. That was one of the problems, is there were plenty of things that happened, and then more investigation was warranted, but then the evidence had been destroyed.
So is it your intention, for instance, if we added under 19, Let me withdraw my motion, just do a conversation for a minute.
It's withdrawn.
And then I'll put it all together. With line 19, if to also to take care of the concern raised, would it resolve the concern if we said at the opening line of 19, at the close of polls at a location where a drop box is located? Would that take care, Sarah, of your concern?
I just want to understand exactly what's intended.
Yeah, I
here.
think what's intended is that you want the surveillance where there's a drop box.
Correct.
Should be the same language about the state authorized.
Hold on.
Is there any estimation of cost implications for the counties?
I don't know, but considering they were under surveillance before, I'm sure that there is some information available. I did not do that research, but I'm sure it's considerably less than opening all these investigations and everything else.
And I might add that
I don't know.
That's a valid question to ask as we move forward. All we're trying to
Yep.
decide today is whether or not to, for want of a better term, to launch the ship. We're not necessarily interested in whether or not it docks. That's,
I like that, Mr. Lindsay.
you know, glad somebody does. I'm joking.
Ready to-
Oh, no, I want to play with this at the close of polls. At the close of polls at a location.
I think procedurally, there are two separate, and please, Russ, if you could weigh in on this. Procedurally, with the petition, we have to do an up or down vote, and then separately decide whether or not to initiate a rulemaking process. Isn't that correct, Russ?
No, 5013-9 says you either reject the petition or initiate rulemaking proceedings pursuant to 5013-4.
But we can initiate on the basis of a different language from what the petition has, is that right?
That is correct.
Okay, thank you.
And honestly, at this juncture, because I think, and I think Ed was the one, and I apologize, my video feed and my audio feed are not synced up, but I believe it was Ed who was attempting to address the provisions in 19. There is some verbiage in 19 that is potentially problematic, even with what I heard Ed's fix was in regards to trying to qualify it at the front end in polling places where there is a drop box, because the operative portion after that contingent intro still requires video surveillance of the polling place, not the drop box. It may be that the board says we're going to initiate rulemaking on these terms, but start over at scratch with a clean sheet to accomplish what the petitioner wanted to accomplish. But there are still some inconsistencies between how the petitioner has phrased things and what she has at least verbalized today what her intent was. The problem is, in terms of what she has proposed in regards to 19, she was wanting video surveillance of every early voting polling location. I do not believe that
If there's a box there.
counties have control of every video, of every early voting location.
Yeah, Russ, I think in talking with the petitioner, I think that she's made it very clear that she only wants the surveillance of where there's a drop box.
Correct.
And that's fine, but that's what I was saying and what I was referencing in my earlier comments, Ed. It may be easier to start from scratch than try to tweak this, because the board will know what it's trying to accomplish in the rulemaking, as opposed to trying to red or blue pen what she has submitted at this juncture. But that's up to the board's discretion.
I
But
do
you
think.
are playing whack-a-mole, trying to undo some of what she had put in there, because the language that she employed in her petition is much broader than what she has articulated today.
Well, I think we can, and I respect that, but I think that we can tweak it, but with some specific language at the beginning of 19.
Or really on line 3 where it talks about polling place. Just
Or
add
line-
where a drop box is located.
And I would also suggest changing language, because polling place is the legal term used for election day, not early voting location. I would not want counties to believe that we're requiring video surveillance of every election day polling place.
How about voting location instead of polling place?
Early voting location.
Early voting location. So,
I'm in agreement with that.
okay. So what we would do is, at the end of that sentence on line 3, simply have, and recording of
The drop box at
The-
the early voting location.
yeah, the drop box at the early voting location. I would put a drop box, because not all of them are going to have one. All right, here's
just
my
to-
motion.
I'm sorry.
Go ahead.
I just had a question. Can you read to me what I don't have the code in front of me, but what the actual definition of a drop box is?
See if I can find it quickly. Or somebody else can find it quickly. Tell you what, someone else is going to look at it quickly. Let me work on let me make my motion.
You go right ahead, Mr. Lindsay.
Let me make my motion while somebody else tries to answer your question.
Thank you.
All right, I hereby move to initiate rulemaking of the proposed petition as amended as follows. On 18, in the first sentence, on the first line, delete, box or any. And on the second line, after postal service, add the words or authorized and defined drop box under Georgia law. And then the additional amendment will be in 19, in the third sentence.
Third line.
On the third line, sorry. The third line, delete the polling place and insert in its place a drop box, whether it happen.
Is that early voting location?
Any drop box at a early voting location. Do you get that, Alex?
Any drop box at any early voting location?
At
Yeah. Yeah.
Any drop box at any early voting location?
Yeah.
We have a motion from Board Member Lindsay, as stated. Do we have a second on that motion?
Second.
You have a motion and a second for the revised, to initiate rulemaking on the revised petition. Any discussion from the board? Hearing no discussion, all those in favor to initiate? Yes.
Just to be clear, did Mr. Lindsay say any absentee ballot other than the United States Postal Service and define drop box?
So any absentee ballot drop-off location.
Okay. drop off.
And then he said after postal service or authorized defined drop box under
Authorized
Georgia
and
law.
defined under-
That's why I was I'm
Yeah,
sorry.
I understand.
Or defined and authorized?
No, or
Or
authorized
authorized.
and defined drop box under Georgia law.
Authorized and defined.
Let's start over so that we can make sure we have this clear.
Okay, here we
Member
go.
Lindsay, if you would restate your motion one more time,
I
please.
hereby move to initiate rulemaking of the proposed petition as amended. In the first line of 18, delete box or any and insert the word off so that the first line before the comma will read any absentee box off location. On the second line, after postal service, add the words or authorized and defined drop box under Georgia law. Under 19, on line 3, delete that polling place and insert in its place a drop box at any early location, an early voting location.
We have a motion as stated by Board Member Lindsay. Do we have a second?
Second.
We have a motion and a second by Member Johnston. Any further discussion on this?
One moment. Georgia law does not describe usually what a drop box is.
Well, let's see what we got.
There's no definition, but there is a very specific legal description of the opening slot of the drop box shall not allow ballots to be tampered with or removed. A drop box shall be labeled official absentee ballot drop box and shall clearly display signage developed by the Secretary of State pertaining to Georgia law. I think that is a sufficient legal description in code for counties to identify precisely what we're talking about here. It is OCGA 21-2-382, C, subparagraph 2.
382.
That seems sufficient. We have a motion and a second. Any further discussion from the board?
Page 307.
Hearing no discussion, all those in favor of moving the motion signify by saying aye.
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 Any opposition? Hearing no opposition, the motion is moved by a vote of 4-0.
Thank you. Thank you very
At this
much.
time, the chair will entertain a motion to recess for lunch.
So moved.
Do we have a second?
Second.
All in favor? Signify by saying aye.
Aye.
Yeah, what the?
Motion carries 4-0. We will recess until 2 o'clock, 40 minutes approximately.
Bye, Russ.
Lee Adams. I'm a resident of Fulton County.
Okay, thanks.
And I am here for this rules proposal as a resident. And I'm also here as a resident that has been involved for several years in elections. And since I live in Fulton County, it's been a lot of involvement in Fulton County. So, excuse me. The elections, I see the elections as a service we provide for eligible voters and also for candidates that are brave enough to run for office. And my proposal is just to provide transparency in the elections. I think that transparency is key. And so what I'm proposing, currently under Georgia law, OCGA 21-2-408, political parties can have 2 poll watchers each in the tabulation center. This doesn't take into effect the different sizes of tabulation centers. And for example, in Brooks County, Georgia, in South Georgia, they have an election day polling location in a big room. Part of the room is the polling location. The other part, they totally tabulate the elections right there. You can come in to vote, and you can see them performing vote review panels. So then you've got locations like Fulton County. It's 800,000 square feet. The tabulation center is absolutely huge, and it's hard for 2 people to monitor what's going on. We have other big counties. DeKalb comes to mind, that you have processes going on in several different rooms. So it's hard for 2 people to decide where to be or what they can see. So this should be nonpartisan, non-controversial. What I'm asking you to do is to take in consideration the size of the county. The bigger the number of registered voters means the more ballots, and more ballots means bigger space or multiple different rooms that processes are going on. So I have given you all the top counties, the ones over 200,000 voters. They're Fulton, Gwinnett, DeKalb, Cobb, Chatham, Cherokee, and Clayton. And the number of counties with 100 to 200,000 registered voters is 11. Okay? I continued down because I thought it was very interesting that we have 123 counties with less than 50,000 registered voters. I'd say we have too many counties, but that's just my opinion, and I'm not going to change that nor fight that change. So what I'm suggesting is an amendment to Rule 183-113-.05, and it's poll watchers for the tabulation center. In counties and municipalities using central count optical scanning vote tabulation equipment, the election superintendent shall allow each political party to appoint 2 poll watchers for each primary or election. Each political body may to appoint 2 poll watchers. Oh, I think I might have typed the same thing twice. But the change would be, with the exception of counties with more than 100 registered voters, shall allow the appointment of 2 additional poll watchers per 100,000 registered voters. So my point is that in small counties, and my examples that I used in your or in the proposal was that Spalding County has 51,689,000 registered voters, whereas Gwinnett has 634,215 registered voters. I've got the Fulton County numbers in here. I also have the early voting locations, and this is really important. For Fulton County, for an example, on Election Day, they will have every tabulator in the tabulation center, and at some point, they will open all of the tabulators and take off the security seals and run the tabulation tapes from those machines. When you've got 36 voting locations, that means that you've got 72 scanners. And half of those typically are in the large cabinets. So you've got a large scanner and you've got a large cabinet with a small scanner in it. To be able to watch that with that many machines, just that process needs more than 2 poll watchers. And so it's just a common sense. I believe when this law originally came into effect, they were used to saying 2 poll watchers. And I believe, I know it was a good while ago, the counties were smaller. All of our counties, big counties especially, are growing by leaps and bounds. So this is just a common sense, making it equitable across all county sizes to let the citizens, who it is their election, be able to monitor what's going on in the tabulation center. And so that's my proposal.
Thank you. I have a small concern about this one.
Okay.
In that I've recently had the opportunity to tour Gwinnett County's facility, which is pretty impressive. And I think about Gwinnett County that has 600,000 voters. And so under your proposal, they would be allowed to have 12 poll watchers from each party. So there's 24 poll watchers in the tabulation center, plus independents. I mean, you could get up to 30 people, running around as poll watchers. And to me, that seems excessive. And it's a lot for those county election officials to have to manage all those poll watchers all over the place. Mm-hmm. And so I don't disagree that for a facility that size, you might be allowed some more, but I think there's got to be a limit on it so that you don't have chaos. And I don't think that you necessarily need 12 of each, party running around there, and then that superintendent or those election workers trying to manage that process too. And so that's my concern about this.
I absolutely understand that concern. And I'm going to be honest, we do have our Gwinnett Board of Elections member here, but I'm not sure about Gwinnett. Does it have several rooms, several different locations that tabulation processes are going on? One huge? Okay.
Yeah.
Okay. Oh, well.
Yeah, I get concerned about all those people overwhelming the staff there and just trying to manage that. So I think that I do agree that in these larger counties, larger facilities, there might be more poll watchers needed, but I think that yours goes a little bit, for me, it goes a little bit too far in adding way too many people to the mix there.
Okay.
Yeah. Mr. Chairman.
Yes.
My problem is a little different in that I can really like your idea. But the problem is I can't, I'm sorry. Thank you all, I do appreciate it. Just feel free to keep correcting me, which I'm sure you will. My problem is just the opposite, and it gets back to this discussion we had earlier. Someone was going, well, just push the envelope. Well, I can push the envelope sometimes, but I can't go beyond the law. And unfortunately, the law says 2. For the counting centers and says no more than 2 for a polling place. I don't know how to get around that, and quite frankly, I don't, and therein lies the problem. I agree, two people, for instance, I've been to Gwinnett County and watched two different elections at Gwinnett County. That was kind of I got chosen to go to Gwinnett, and I had a great time. Gwinnett, you guys have a great facility up there. But two people couldn't possibly be able to observe everything that goes on there. I don't know what the right number would be. Probably less than 12, what he's concerned about, but two's probably too few. The problem is the law is very specific. It says that the parties may select two people. And if that's what the law is, then that's something that we need, and we do have a duty periodically. Usually we try to do it in December to make recommendations to the legislature, because they always have election bills, to make adjustments. And I'm afraid that's where we're going to have to go with this one, because the law says two. Unless you can tell me how I'm going to be able to say the law's wrong, or come up with another way around it.
Okay. I've got a few things to say to that. First thing I want to do is get my inner Sally Grubbs going.
I know, but, and Sally didn't ask me to break the law. Sally asked me to figure out a way to make what she wanted fit within the law. And we did. We worked very hard to do that, and because I thought hers had merit too. The problem is here, the law is very specific. It says two. And
well, in my opinion, two things. This amends the law for larger counties. It still says two poll watchers, but it's growing with the growing times.
Oh, no, and I agree with you. The law needs to be changed. I'm not in any way disagreeing with you. I agree with you.
Okay.
Because when they came up with two, they probably weren't anticipating a facility like Gwinnett has, which is great, a facility like Atlanta has, or rather Fulton has, and Cobb or DeKalb for that matter. They weren't anticipating that. Mm-hmm. The problem is that nobody has fixed that legally. And we simply, we are a body with limited jurisdiction. And one thing we can't do is make a rule or make a requirement for a county that exceeds what the law says we can do. That's my problem.
One thing this board can do is create a resolution to send to the legislature, asking them to increase the number of poll watchers. We can do that.
Well, let me just ask you a question. And I mean, like was discussed before, that any of these rules amendments would go through the Legis Council. I can't remember exactly what the term was. Would that be something that you all would feel comfortable with? Because it would get kicked back, is my understanding, if it wasn't within the parameters of the law.
The problem is that the law here is very clear. I'm happy to make a motion for a resolution right now, as a matter of fact, that the law needs to be changed. But when the law is quite frankly very specific, I can't just ignore it.
I think that we create a lot of issues for this board when we try and pass rules that are in direct contradiction to what the statute says. Mm-hmm. And it's a more honest way to treat this would be for this board to pass a resolution recommending to the legislature that they increase the number of poll watchers. If it went before legislative council, they couldn't change the law. I mean, that has to go before the legislature to change the law, and they don't have the ability to do that. They're just reviewing it, I guess, to make sure it confirms to what they want, but they can't change the law at that period. So this one needs a change in the law itself.
Mr. Chair. Go ahead.
Yep.
The only thing I wanted to point out is that there is a separate provision for observers for the absentee ballot processing. So that is, if it happens to be undertaken in the same area, the law provides for 2 tabulation observers and 2 observers for the absentee ballot processing for a certain extent. I know that's not what you're looking for, but those are separate. They have separate approval processes, and those are both are allowed under the current statute.
Thank you for that.
Member Johnson?
Mr. Chairman, a couple of things. The rule designates, as far as 183.113.05, designated locations designated by the election superintendent. And they actually name two, they say two poll watchers for each location in the tabulating center, and they actually name the check-in area, the computer room, and the duplication area, and other such areas as the election superintendent deems necessary. So actually, our rule conflicts with our law. If you're saying that we can only have two, it already conflicts with the law.
I can't speak about prior chairman.
Right. Oh, yeah. I'm not saying. I'm just saying. I'm just saying. Okay. So so actually, Ms. Adams, you could have
Actually,
according to our
the law does allow two at the. Let me be more specific. The law allows for two in various locations. I'm just simply saying that you cannot simply just have more than two in the various locations. It does have two in the various different locations already.
Right.
Underneath the rules and underneath the law.
Okay.
The rule simply follows the law.
Okay. So the rule does follow the law. So you already are designated in certain areas to have two in each of those areas. And actually, seems to be some conflict in the law on 21-2408, paragraph A, 3A. It refers to Code Section 21-2380, which really doesn't have, I don't think it has anything to do with the observers. It actually speaks to absentee elector defined, and an elector who votes absentee shall not be required to provide a reason in order to cast a ballot. Somehow or other, it doesn't make sense.
Right.
So another resolution to recommend a change to our General Assembly.
I'll support that. So I'd like to ask, just for clarification, are you talking about two additional poll watchers per location that these are in, or you use the word area, but I didn't.
Can you read the rule?
So the rule states the political body to appoint two poll watchers for each election, and each independent candidate and each nonpartisan candidate to appoint one poll watcher for each to serve in each of the locations designated by the election superintendent within the tabulating center. Such designated places shall include the check-in area, the computer room, the duplication area. So those are three different locations in a big 800,000 square foot warehouse, I guess. And other such areas as the election superintendent may deem necessary to the assurance of fair and honest procedures in the tabulating center. So
that's at least six.
So it's at least six.
Yeah, and that follows, just for the records, Dr. Johnson.
Right.
And you can continue. That follows OCGA 21-2-408C. That's in there.
Okay. So as the superintendent, Ms. Adams, are you a superintendent?
Well, according to law, I am. But according to my elections department, I'm not. We've delegated those duties to our elections director.
So the areas as the election superintendent may deem necessary to the assurance of fair and honest procedures in the tabulating center. So the superintendent is the Board of Elections and Registration. So I think it would be appropriate for your board, if you deem necessary for the fair and honest procedures in the tabulating center, to designate additional, but being mindful that one wouldn't want to interfere with the conduct of the election or the workers that are performing their duties.
I believe that there are a lot of counties that don't observe that, especially when it's a county that it's one big room that all these processes are going in. I believe that I have yet to see a county, I mean, I haven't been to all 159, I'm sorry. But I believe that most counties see that as two totaled, if they have it all going on, even if they don't have it all going on in one room. But would it be appropriate for the board to send a memo or something clarifying this for each of the counties?
I believe so.
I think the law is not entirely clear, because when it says each political party may appoint 2 poll watchers in each primary or election, and then it goes on to enumerate the locations where they can be observers. I think that to say that each election and then in each location where it does not refer to the numbers, I think that is stretching the law beyond what the plain text of the language would hold.
The rule that was adopted, though,
But
clarifies that
the
further.
legislation is where we go from, where we start out with. The way I read the legislation is each, and I do believe it's out of date, and I do believe that it should be more, not as many as perhaps you would like, but I do think that it would require more. But I think the plain text of the legislation says each political party may appoint 2 poll watchers for each election. And these are the areas within the tabulation center that they are allowed to observe. That's how I read the legislation. And if I, as an attorney, have a different reading from a different attorney, I think that an interpretation would be better to come from either the general counsel's office or the attorney general's office. I don't think that if we can't come up with something that we can agree with, we are putting counties at risk and the parties at risk of violation here. And I don't want to do that.
Are you referring to? If we get 4 attorneys, we'll get 4 different interpretations.
Yeah, that's exactly right. Exactly right.
Are you referring to 3A, A3A of 408?
I am referring to A3C. (21-2-408). No, I'm sorry, B3C.
And,
I don't have a
and
C.
the language is, in the rule language, is 183-1-13-.05, which is basically word for word what the statute.
Yeah. Which is really not helpful.
B. What page, Sarah?
348.
348.
C at the bottom of 348.
C.
Oh, that's just C.
Yeah, C.
408C.
And the rule is at 576.
Oh, you're right. You're right. You're right. 408C. Is it 506?
576.
576, yeah.
So so 408C says the poll watcher in each election is served in the locations designated by the superintendent within the tabulating center. It is consistent then.
Yeah.
Such designated locations are the check-in area, the computer room, the duplication area, and other areas as the superintendent. Oh, it just copies the rule.
Like I
But
said,
but it's all one sentence.
Yeah.
It's all one sentence, which means it's, the way I would read it, and I'm not an attorney, I don't pretend to be one, but it's all one sentence, so to me it reads that you're allowed 2 poll watchers in each location in tabulating, because it's all one sentence.
And other
It didn't say 2 poll watchers, period,
It says 2 poll watchers in each primary or election.
comma.
Right. And then each political body, and then each nonpartisan candidate.
Looks like it's very
Comma.
liberally construed.
Right.
Give the superintendent
To serve in the locations designated by superintendent within the tabulating center.
in each of the locations, that's the key.
Right, to serve in each location
Yeah.
in each location to serve in the locations designated by the superintendent within tabulated center. Period.
Problem solved.
So you leave it to the superintendent to interpret that.
Yeah, I don't think it's clear.
Yep.
I think you could read that either way.
Y'all can send the letter.
As I said,
But-
I'm not.
So it appears to be a rather liberally written statute to allow the superintendents to, at a minimum of 3 locations and more as necessary for watching or actually public observation. All election processes should be available to the public for observation also.
Correct.
I think it's already addressed in statute.
I think that based on the, I want to be nice because I'd like for y'all to, but it seems like there was dispute on how it was written. And I think that most counties see it as 2, no matter what's going on, 2 total. No matter if it's different locations, areas, rooms.
It's interesting how if a county decided to have 6 poll watchers and somebody complained about it, and the case came back before the board, how would the board vote on that?
Well, I think the superintendents have the discretion in here to make those determinations. Yep.
Yes.
It is designated, it explicitly authorizes the superintendents to determine.
But counties, the plain text of the law, counties, there are some counties that the superintendent is not the Board of Elections.
Well, it
Which is
that's
clear.
right. In some cases, it's a probate judge, and they are the superintendent.
Right.
And the counties in which the board is the superintendent, the board makes the determination.
Yeah.
As a board.
That's probably creating some confusion.
But some counties don't do that.
Mr. Chair.
Is that enough non-committal for you?
Pardon me?
Yes, Member Johnson.
So there's probably some confusion that's been generated by was this the Secretary of State?
This was given to me by the Secretary of State's office, the template for our poll watcher letters that we send out. It says no more than 2 statewide poll watchers of a particular party may be in the same voting location simultaneously.
The voting location is different from tabulation center. So that's just for the
Yep.
statewide.
Yep.
So,
Statewide, yeah.
yeah.
That's a
And
voting
That's
location.
a voting location, not tabulation center. So let's,
Let's
Don't want it
let's not mix
misinterpreted.
it up there.
Right.
Yep.
yeah,
We can just get a little more confused. That'll be fun.
Yeah.
yeah. Let's not do that.
Bottom line is, I think we're going to need to get some clarification from the legislature. And we're going to need to ask for that clarification.
Okay.
I don't think the board opposes this rule, but the board doesn't see the need for this rule because it's already in statute that you're allowed more poll watchers.
But not clearly.
Well,
Which is
there's
what-
there's a whole lot in here that's not clear.
And that's
So it's
true.
Which is why we need to ask the legislature to clarify.
Right.
And to
I mean, I believe it's one of the big reasons that you guys exist is because the laws are not always clear
Yeah.
and for clarification.
Yeah, no, and I agree, but I can be the mortar in between the bricks, but I can't be the bricks. How about that?
Right.
And when the bricks sort of set a limit, I can't. I'm mixing metaphors, maybe, but anyway, I can't go beyond that.
Okay.
Is there a problem?
Do it.
So, all right.
Yeah, the chair will entertain a motion on this petition unless the petitioner would like to withdraw it.
Well, what I'd really like to ask is if you could give guidance to the counties on the different areas.
Would the petitioner consider moving this petition to the next meeting so that we have time to get some direction on this?
I would be flexible about doing that, but I believe that would put us past the general election in 2024, which is
Yeah.
the biggest election we'll have
No,
for the next
July.
4 more years.
July.
You have a meeting in July?
Yeah.
Well, it
We
hasn't
will.
been announced yet. We've
We
discussed
definitely have
that.
one in August, but
Okay.
but we intend to have one in July.
Yeah.
Okay. Then I would be happy to put it off till.
I would also recommend that you consider bringing the language a little bit closer to the statute, because as it stands, this is entirely outside what legislation allows. But there, if you try to make sure that you stick within the universe of the flexibility that is contained in this bit of legislation, it would be a different calculation that we would make. Rather than like strict numbers, looking at the construction that the legislature has created.
Absolutely.
If
I
we
appreciate that.
continue this to the next meeting as is, then we will have to vote on this. If you withdraw it, then you can revise it and resubmit it for the next meeting.
Okay. I will withdraw and resend it in.
All right.
Thank you, Mr. Adams.
Mr.
Thank
Chairman?
you.
Yes, I'm sorry.
I'd like to make a motion that we send a letter of instruction to all of the county Board of Elections and supervisors pertaining to the particular law at 408 and Rule 183, 113.05, expressly giving them direction of the ability to have poll watchers in designated areas and as deemed appropriate, just as the law allows and the rule provides for poll watchers.
So you're asking this board to make the interpretation, make a more liberal interpretation of this, I don't even know if liberal is the right word, interpretation of this statute so that more than 2 is allowed in tabulation centers.
No, I think what she's asking for, I'm sorry.
Go ahead.
I'm not going to be.
Tell me what.
What's your motion?
I'm not going to be accused of mansplaining.
Come on, man.
I'm just not. You can't make me, and I'm not
Come
going to
on,
do that.
come on.
I'm just not going to do that. But I think, but if I may be allowed to say what my interpretation would be, to simply make sure the superintendents realize that they have the right to appoint 2 in each of these designated areas, underneath both the rules and the law. And we might even send it to both the board and the superintendents and let them squabble about how to get it. And that puts everybody on public notice.
Correct. And I would also make sure that when we send the letter, when we speak, when we say superintendent, that we specifically designate the Board of Registration and Elections.
Yes.
In those counties that have boards.
Yes, in those counties. Correct.
Or the probate judge.
Or the probate judge.
But SB 212 changed all that. But that's not until July.
Right.
Member Johnson, before I ask you to restate your motion, are you volunteering to work with Alexandra on developing that letter?
I would be delighted to.
Thank you. And would you restate your motion, please?
Mr. Chairman, I move that we send a letter of instruction to all appropriate counties, Board of Elections, and supervisors, reiterating the provisions found in OCGA 408 and State Election Board Rule 183, 113.05, describing the ability of appointment of poll watchers to designated areas and other areas as deemed necessary to ensure what is the exact word? The assurance of fair and honest procedures.
Member Johnson has made the previously stated motion. Is there a second?
Second.
We have a motion and a second. Any discussion? Hearing no discussion, all those in favor of passing Member Johnson's motion signify by saying aye.
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 Any opposition? Hearing no opposition, so moved by a vote of 4-0. Thank you, Ms. Adams.
Can I just say, I really appreciate all of you considering this and doing this. And you've mentioned many times that you've been in other counties and things like that. I would love to invite you guys to Fulton County anytime you'd like to come see it. And we do have a board meeting tomorrow. If you'd like to come, I can show you around afterwards.
I can guarantee you that I ain't gonna be there.
I can promise you that the board chair will spend some time in Fulton County. And please tell others that we do something occasionally. The next item on the agenda is petition for amendment of state election board rule presented by Marilyn Marks. Is Ms. Marks here?
She is.
Good afternoon, Mr. Chairman and Board. Thank you so much. My name is Marilyn Marks. I'm the Executive Director of Coalition for Good Governance. You all should have a very small slide deck that Alexandra was going to hand out to you to hit the high points here. Excuse me. And for people who are watching this, if you want to see the slide deck, you can go to our website, coalitionforgoodgovernance.org, or I tweeted this out today under Coalition Good GV, Coalition Good GV, and you'll be able to see this small slide deck. I want to make one thing clear. We are not trying to address hand counting in the original count of elections. This is about recounts. We do not support hand counting for large elections for the original count. We believe that the ballots should be scanned by optical scanners and then thorough audits done. This is about the recount rule that the board currently has in place, and we want to ask that you bring that in compliance with law, which I think pretty clearly requires manual recounts. Also, I want to make clear, as you've had in the last couple of presentations, we would very much be open to making any friendly amendments on the spot so that we don't have to wait for another cycle to bring this to you. So please recommend any changes that you feel like you need to, because this rule, as I think you'll see, is urgently needed. In fact, if you felt like you had the emergency rulemaking powers to do this, I would encourage you to consider adopting it on that basis. But certainly, the rulemaking process needs to begin very quickly. We're looking at, primary elections this month. We'll be looking at runoffs next month. And we could very well find that there are recounts that need to be done, and they should be done in a way that the candidates don't have to feel like they have to bring a lawsuit to get it counted by law. So when HB 316 was passed in 2019, the legislature said that recounts and audits would be done based on the paper ballot printout. And while that might have been a little vague, it's clear that this board saw that to mean that for audits, you need to do the manual count. You need to be looking at the printout of what the human readable text on the ballot. And certainly, that should be, the count for the recount should be consistent with that, just as the legislature says. Since that time, Judge Totenberg, in the Curling case, in her order on the motion for summary judgment that this board made, in just recounting the laws that were in place, she made the interpretation, not that it had been subject to question, but she just made the interpretation as she was talking about procedures, that recounts would be governed by the human readable text that would govern the outcome of a recount rather than the QR code. That happened, I guess, in November of last year. And then more recently, in March, just last month, When the State Election Board and the Secretary of State filed their proposed findings of fact and conclusions of law, what was proposed was that you ask the court to find that recounts and audits should be conducted by human inspection of human readable portion of the paper ballots according to the state's expert. And further, asking the court to find that the current system is in compliance with this recommendation. But the rule that had been adopted by the previous election board had called for machine recounts instead. And so we believe that is an error, not with the current thinking perhaps of this board or other the interpretations of the law. And so we are asking that you promptly act to use manual recounts rather than machine counts. Having a requirement to have a machine recount and then go to a court, for a candidate to have to go to a court to get a manual recount, which is what the law requires, can be really burdensome on a candidate. It's an expensive thing to do, to have to file a lawsuit to do that. But also, your current rule does not really tell the candidate what he or she needs to do. If you've got a candidate that may be running a race in, 12 counties, do they have to go to 12 counties to file a lawsuit to get a manual count of their ballots across the 12 counties? That was really burdensome, unfair, and after all, it is the law that the manual recounts are required. And obviously, as we've seen in 2022 and 2020, machine recounts can cause unlimited post-election controversy that could be solved with manual recounts. So what's wrong with a machine recount? Well, if the QR code is erroneously programmed, and we've seen that happen, if it's hacked or just human error caused the programming problem, a hand count and machine count can end up showing significantly different totals. And recounting it by machine, you're going to likely get the same total you did before, and it may be the wrong person who is being declared as elected. In fact, we all know that that happened in May of 2022 in DeKalb County, when there was a coding problem and the machine count was quite different than the hand count, and in fact reversed the election completely in terms of who won. If the SEB rule had been proper at that time, what would have happened is, before any kind of certification, when they realized there was a problem, there could have been a manual discretionary recount under the law. And then the corrections could have been made in a legal way prior to certification. But that wasn't really available to anyone. And DeKalb had to really go outside the law to create a process to hand count the ballots. Another example, and you all talked about it yesterday as part of the Rossi complaint. Of course, here we are 3.5 years later, still dealing with controversies of, were the ballots counted properly in 2020? And were certain ballots double counted? Or were some ballots not counted? Had there been a proper recount according to the law, that controversy would have been over in November 2020. And the thousands, tens of thousands of hours that this board, the local boards, and the legislature has spent dealing with the controversies of the 2020 count in Georgia, those thousands of hours would not have been necessary, because there would have been a manual recount, quite different than anything that happened at the end of 2020. I was surprised yesterday to hear references made to a hand recount in 2020. There was no hand recount in 2020. There should have been, but instead there was a machine count, a hand count audit, which is nothing like a manual recount, and then there was a machine, an improper machine recount. It has never made any sense to me as to why Mr. Trump did not ask for a recount, a manual recount, or why Secretary Raffensperger did not want a manual recount. It would have resolved so many problems right there. We don't really need to relive that again in 2024, either for the primaries or for the November election. And this can be easily solved by having the appropriate rule made to go to the manual recount as required. I also include in the rule proposals to deal with the opportunity for discretionary recounts, which have been in the law for a long time, but they're not very much used. But it is the great opportunity for a candidate or a campaign to be able to get the election superintendent in the county to look at potential problems. Maybe they don't hit the 0.5% recount threshold, but before we get to certification, if there's a problem, but have the opportunity to seek a discretionary recount, which is in the law now. But what should happen, though, is that the boards need to be able to deal, or need to be required to deal with those discretionary recount questions in a transparent way, actually force them to make their decisions in public, and then those discretionary recounts should be manual recounts under the board rule so that controversial errors can be resolved before you get to certification. Given the November 2024 elections upcoming, so there's such high stakes. We know we don't have any argument about that. The nation will be watching Georgia. It makes all the sense in the world not to relive the kind of controversies we've had before. And the controversies are probably positioned to get even sharper this year because the touchscreen system has been demonstrated to be vulnerable to undetected vote manipulation. BMDs, we now know, have generated tallies that can be inaccurate, but no mitigations have been attempted for the known vulnerabilities. Since that time in 2020, the election software has been stolen and distributed to unknown numbers of unauthorized people. The software is in the wild. There have been no mitigations. And then, just in the last month, we've seen a cyber attack on Clarke County. It is unknown as to whether or not their election infrastructure has been affected. There's so many reasons that we are facing risk in 2024 in November that a manual recount can go a ways to trying to resolve on the front end and know that many of the controversies can be solved with an appropriate rule in place. So we would wrap up by saying that manual recounts are required by law, by best practices that this board has even said to the court is the best practice and should be done, and by the current risk environment that we are in that's an even greater risk environment than we were in 2024. So with that, I'll be happy to take any questions. And again, if you can consider proposed rulemaking on an emergency basis here, since you're not meeting again until July, we would really encourage that, given that we've got at least 2 elections to certify before the November election. Any questions?
Ms. Marks, what is the error rate in a hand count?
That has been, there's no one answer to that. That's been debatable for years, but that's not what we're talking about here. We're not talking about a hand count. We are talking about a hand recount.
It is nonetheless a hand tabulation of ballots where in the only cases where a recount is authorized is when the margin is 0.5% or less.
That's not quite right.
It's the only recounts that are that are by law are granted at the request of a candidate are when the margin is 0.5% or less. I have yet to find a study, and I have read a lot of studies, where the margin of error is even remotely that small. In other words, hand counts are everyone that has been studied by MIT, by organizations, by the Brennan Center, and that has been conducted across the country. The margin is greater than the margin of victory. In other words, a hand count can erroneously change the result of an election simply through human error. And that, to me,
No, that's incorrect. That's really incorrect.
Let's be respectful of our speakers, please.
every study, every scientific study, if the printed ballot is a reliable enough indicator for a hand count, it is also a reliable enough indicator for an audit. I would be wholly supportive of and this is something that I recommended in 2019. I would be wholly supportive of a mandatory audit of any machine recount. But to do a full count, especially if we're looking at a statewide election, we know that takes days and days. And even when it's done in abbreviated fashion, it is still an incredibly chaotic event. And every hand count that we have seen across the country in the last 24 months has resulted in enormous errors.
I don't think that is correct, but regardless, what we have proposed in our rule addresses on the front end making sure that it is an accurate hand count, as numbers would be reconciled back to the machine count to try to find where the errors were. And given that we know we don't have reliable paper ballots for all sorts of reasons, and we know that we've got problems, the two elections that I mentioned, May 2022 in DeKalb, I don't think there can be any reasonable argument made that we should have accepted what came out of the machines.
And we didn't, because that was an occasion, and I would argue that it was wholly within the confines of the law, because the machines, they could not certify the machines on the recount, and they justifiably did a hand count, and it was a programming error. But if the ballots are reliable enough to trust a hand count, if they're a reliable enough record to trust a recount by hand, they are a reliable enough record to trust a machine count and an audit.
That's very different.
I understand, sir.
But we don't accept the proposition that if it's reliable, and in many of the ways, we don't accept that proposition. But I would suggest that as you work through the logic and you work through the law, there was a reason that the law was made to say, use the paper ballots and what is reflected on the paper ballots as the basis of a recount. We have seen many reports of BMDs being misprogrammed, and the QR code or the barcode has been miscounted.
And an audit would identify that.
No, it wouldn't. No, it wouldn't, particularly with Georgia's audit laws. It absolutely would not, unless that race happened to be caught, selected for an audit. But we know that under the new law that's going into effect, that the selection of what race is going to be audited is going to be done on a subjective basis by what many people have considered to be partisan-driven operation. So there is no assurance that an audit is going to catch the kind of errors that you're talking about. Also, I would say this board has already said that it is best practice to do manual count for the recount. And experts across the land agree on that. It's hard to believe that we're even having this debate about whether or not the manual recounts appropriate to do. Even if, yes, there are errors in hand counting and there are errors in machine counting, and that's the whole point, is to try to make sure that if there are machine count errors, that they don't survive. But if you notice our rule, it does require reconciliation. Find what the problem was, not just accept whatever the hand count is as the gospel.
If you would, ma'am, tell me exactly where in 21-2- thank you. Tell me exactly where in 21-2-495 do you believe that the recount has to be done by hand?
It's not in 495. It is in 379. Oops, I've got a bad site here. It's in 21-2-379. Is it 25?
Okay, that's fine. I'm looking at your thing. That's
Yeah,
right.
but it's talking about a reference to a hand
That's
count.
fine.
Excuse me, to the recount. It's saying,
Are you looking at 21-2-379.23D?
it's probably point 23, yes. I had a typo.
Okay.
Yes, that's exactly what it is. Thank you for the correction. But it's just referencing 495 as the recount statute.
Twenty-one -2-379.25, you said?
I think it's 23.
Oh, there we go. Okay, I got it.
And I think I've cited it here on the second page.
I got it. Okay, I'm sorry. I see that now. I missed it earlier.
Well, it didn't help that I had a typo in there.
When I read that statute, that particular statute, I think that you could just as easily interpret it that, yeah, you have to use that paper ballot that is produced when you vote, but it doesn't tell me whether I have to count that by hand, or whether I can take that paper ballot, put it in a machine and count it. And that's what, when I read it as a non-attorney, just a person, it doesn't tell me whether I have to count it by hand or count it by machine.
Right. It could be worded more clearly, that's for sure. But this board has interpreted that for audit purposes, it means hand audits. So if you read that the recounts, that your official vote for a recount is the machine vote, but your official vote for a audit is what's printed on paper, that seems like a very inconsistent interpretation, and you end up with an illogical result, that you would end up with a different number as your official count.
How many ballots are included in an audit?
It will totally depend on the size of the election and the margin.
Is it? But you're not counting every ballot, you're auditing a certain number of them.
That's right, and that's why you don't end up with an official count there.
Is it possible that for a county like Gwinnett that has 600,000 voters, how many is it exactly? 630, 640? 600 plus thousand voters, and they wanted to audit that election, they may choose to audit 10%.
Well, that's a whole new debate. There's a whole new debate about what they can do under the new law, but generally, what we would hope is that they use the risk-limiting audit formulas, and that will determine how many ballots.
It's only a
based on-
percentage of the total vote.
No, it's not exactly a percentage, but obviously it'll end up with a percentage of the total votes.
It's not the total vote, it's percentage of the vote.
It's usually a small fraction unless the margin is really, really thin.
Could it be, and I hate to put myself in the mind of a legislator, could it be that the legislature thinks that it's okay to do a hand recount on a audit because it's a less number of votes that they have to deal with? And when you're looking at a huge number of votes, it's okay to do a machine count, but with an audit, which is a much smaller number, it's okay to do a hand recount.
It would be pretty inconsistent for them to say, well, we want you to do an audit, but that audit will not mean anything. Because generally, what most states make clear is that if you do an audit and you find a discrepancy of any significance, what the solution to that is to do a recount. Then to go back and do a machine recount when you know there's a discrepancy there would be illogical. So it would seem logical that the legislature means what it seemed to have said is use the hand count to determine what your official result is.
What if you do 2 hand counts and they don't match?
I don't know why you would do 2 hand counts. Are you talking about, if you did 2 hand counts and they don't match, and that wouldn't be surprising, you'd reconcile and find out why. Just like we are recommending that if there are material differences between a machine count and your hand recount, that you reconcile them and figure out, oh, did we miss a precinct? Did we count something backwards? Are we missing a box of ballots?
Why couldn't you just do 2 machine counts and reconcile the difference?
Because
If
your
there was
machine, like in DeKalb County, may be counting incorrectly.
As a hand recount?
No, I thought you said 2 machine counts.
No,
I
said
apologize.
It's possible to find inconsistency when you do 2 hand counts, correct?
Oh, it is.
And it's possible to find inconsistencies when you do 2 machine counts.
It absolutely is, right. And that's why normal practices would be, if they are significant at all, then you reconcile and try to find out why. You don't need to track down every single small difference, but if you're showing any kind of material difference, you would definitely try to reconcile and find out why your counts came out differently.
Mr. Chair, or Ms. Marks?
Yes.
Technology certainly improved and become more available and more cost-effective.
At least more available. Sometimes maybe we've gone
depending
backwards.
Depending on who you ask. So optical character readers will actually read the text, the printed text on the ballot. Would you consider that a viable option for a recount?
No, absolutely not. Because, one, it's not part of the state certified system. We can't just have kind of random technology thrown into an official vote count situation. The state has said you're either going to hand count or you're going to machine count, depending on what stage we are in the election. Not, oh, we're going to bring in some new technology that hasn't been certified, hasn't been tested, and it will be the official vote. Remember, our recount is going to be the official tabulation, the official final number. So it really needs to be something that we have high degree of confidence in.
So when QR codes are no longer on Georgia ballots, which some people predict that will eventually occur, will a machine count of the marked ovals suffice for an adequate recount?
Certainly not. No, because as we all know, scanners can be misprogrammed as well. And in fact, I believe that's probably what happened in DeKalb. And if scanners are misprogrammed, we don't want to get the same wrong result twice.
Correct, because you're only measuring the intersection of an X and Y on the ballot when you're using your optical character reader or you're reading a QR code, right? So would a machine count with a mandatory hand counted audit provide the necessary validation of an accurate count?
I don't think so. No, I don't think so, and I don't think that would meet what the legislators wanted. Because remember that, if you're going to set, if I understood your question correctly, if you're going to try to do an RLA, is that what you were meaning by an audit?
I'm not interested in RLAs.
Okay, so what kind of audit are you thinking about there then?
I'm interested in a more traditional audit.
Right, but if we've got a race that qualifies for a recount, we're talking about a margin of 0.5% or less. So it's going to be awfully hard to select a sample where you're sure, a small sample in an audit, that you're sure you are going to find the right winner with a machine, auditing a machine count. Your sample size is going to have to be so large, you're going to end up with lots of ballots to have to, and then you'll still won't be at 100% confidence level. You'll still be probably, I don't know what your assumption is when you're saying doing the audit, but I don't know if you're thinking a 90% confidence level or 95%. Okay. But we're talking about when we do really, really close elections, need to have that level of assurance that we got it right.
Do you know how often recounts are I know you have all the research, how often recounts are done in Georgia?
I don't. We could go back and figure that out. We tend to hear about them more at a county level. Sometimes they don't really get reported up to the state. So I don't have that research. But it's not like it's happening every day and causing the election officers to have to work for weeks on end. We're not talking about hand counting every race on every ballot. We are talking about those that qualify for a recount under the law that is we just talked about, that less than 0.5% margin, or a discretionary recount when the board concludes things don't look right here. We need to do a recount before we certify.
Ms. Marks, just my personal opinion, human error concerns me equally as much as machine error does. I've been in business for a long time. I was a math major in college, and I think I understand counting a little bit, but most of the people that I deal with don't, unfortunately. And I worry about human error a lot. And I probably worry less about machine error than I do human error, frankly, from my own personal experience, and because I see so much of it. And it seems like every time that we have a major hand recount or count of something, I remember the horrors of the Bush-Gore, I guess, election in Florida, where they're looking at hanging chads and trying to decide who won that election, and the weeks that it took to do the recount in Arizona and things like that. And I worry about those kinds of things when we talk about hand counting of ballots. So that's just a personal issue that I have to.
But of course, that's not what we're talking about here. Hanging chads are a thing of the past. That's not hand counting of marks on a ballot. What Arizona did, that was not a recount. That was a whole different animal driven by some really illogical things. That was not a hand recount. And I'm guessing, just because I've been in the trenches for so long in different states, I've probably observed more large hand counts than most people in this room have. And I'll be the first to tell you that large hand counts do find a number of inaccuracies, and they are very hard to do, and they are hard from a chain of custody standpoint. That's why we would never recommend that be the first count. The first count needs to be a quick machine count. But we also see lots of programming problems in scanners and touchscreens, et cetera. And the only way you can solve for those programming problems and potential hacking problems is to have a hand count to mitigate against those machine counts. And again, I agree with you that hand count has error potential, just as machine counts do. But hand count has error potential. That's why we said reconcile any significant differences, go figure out where the problem is. And one of the things we suggested in our proposed rule is use the machines, if you need to, as a resource to help you with any discrepancies that you have. Put them back through the machine and see if you can see if that helps you figure out where your discrepancy is. But if you've got a programming error, you really need to do a hand count. There's just no way around it. And I would respectfully disagree on DeKalb. DeKalb had to go make up rules that are not anywhere authorized by law or by your rules. They had to make something up to end up creating a count for certification purposes. I guess, bottom line, though, it seems that regardless of what our personal opinions are, the law as it would be interpreted in a consistent way, as interpreted by court, as interpreted by the board's experts and the board's attorneys who asked the court to find in their findings, in the court's findings, that recounts be done manually.
Who's this
Sorry?
Who's this that asked for it? You said someone from the state, in the states?
Your board and the Secretary of State in your proposed findings of fact.
Do you have that with you?
I have a cite. Yeah, I do have it with me.
Yeah, let me see.
And it's also on here.
You mean they asked for it in the brief to the judge?
Yeah.
I'd like to see that.
Okay, the site is, and I'll definitely get it to you, but it's at document 1821, paragraph 108.
Do you have the language, or do you
Yes,
have it on your
just
computer?
if you'll give me 1 second, I'll pull it up.
Yeah.
Yes, you all.
Document 1821?
Yes, 108.
I'm sorry, you said document?
1821. I know, it's crazy to think we're at 1800, huh?
Yeah. And it was at page 108?
I think it's paragraph 108.
Paragraph 108.
Right, and you all were quoting Dr. Juan Gilbert.
I want to make sure that you're saying that was the position
maybe
of
it was-
the lawyers for the state advocating that this is what should be done?
Mm-hmm. Yes, and that what is being done. I'm sorry, I said paragraph 108. It is page 108.
Okay.
So the language of it reads this. It's paragraph 459. This is referencing Juan Gilbert, Dr. Juan Gilbert. You were expert. Specifically, Dr. Gilbert testified that the National Academy of Science reports recommendations that, quote, elections should be conducted with human-readable paper ballots, period. These may be marked by hand or machine using ballot marking device. They may be counted by hand or machine using optical scanner. Here's the operative sentence. Recounts and audits should be conducted by human inspection of the human readable portion of paper ballots. Then it goes on for a while. And then, again, this is in the proposed findings. The court notes that no party disputes that Georgia's BMD system conforms with this recommendation.
Can you mind if I see that?
Certainly.
I'm sorry.
And no problem. And let's see, that's where the paragraph starts. That's the national account.
Okay, I understand. Yeah, sorry.
Oops.
I got it.
Okay.
I got it. Somebody else can ask questions to you.
Would not a hand-conducted audit of a machine count also be a hand examination of the human readable marks?
It would be an examination, but it wouldn't be a recount. I think that's the same question that Dr. Johnston had.
Yep. Beg your pardon? Just kind of reiterating that a machine-conducted recount with a hand audit afterwards, I believe, fulfills the would meet the recommendations by the National Academy of Sciences as well. So I agree with you. Just write it down.
So the sentence says, recounts and audits should be conducted by human inspection of the human readable portion of the ballot, paper ballots. I understand your concerns about the accuracy of hand counting, completely agree. But your accuracy is going to go up remarkably when you're only counting one race. When you were doing it under SEB rules for a manual recount, you all have very clear and really, really good rules for manual recount. And one of the great things about it, unlike the machine recounts and unlike the hand count audit that was done, is that each campaign has a assigned counter at that table, so that you've got somebody from the Republican Party, you've got the Democratic candidate's campaign there. The Libertarian candidate has the chance to be at the table as a counter. And so you've got, all of the interested parties, along with watchers, along with transparent tally sheets that the public can have overview. This is how you build confidence in elections, is having a transparent process like that.
We may have good rules, but we don't have good training, and this is not the sort of thing that can be done at the spur of a moment. I mean, we've seen time and time again when the state and the counties are caught flat-footed and with being thrown into a new process or procedure, it is error-ridden. And I cannot imagine between now and November being able to train 159 counties and giving them the responsibility to recruit thousands and thousands of volunteers to conduct this. And to have that more accurate than 0.5%.
Well, what are you going to do when you know you've got a machine you've got a machine programming problem?
Correct. The Attorney General has a comment.
Okay. Yes.
The chair recognizes the Attorney General's office.
Thank you, Mr. Chairman. As you're aware, contrary to some earlier erroneous assertions that this board is somehow advised by the Office of Legislative Counsel, we provide counsel to the board. I will say I'm sort of hampered in regards to this petition. for the reason that our office had to declare a conflict in the litigation brought against this board by this petitioner. Ms. Marks and her coalition are an adverse party to this board in federal court in litigation that our office is not representing the board. Ms. Marks has now gone beyond the petition and is attempting to buttress the arguments in support of her petition by alluding to items from the docket in the curling litigation in which she remains an adverse party to this board. As a result of that, and not knowing what the unintended consequences of adopting this rule, which have been unsuccessfully pushed by Ms. Marks and her coalition in the 7 years that that litigation has been pending, I believe it would behoove this board to reject Ms. Marks's petition so that it can consult with its attorneys in curling to make certain that should the board engage in rulemaking, it does not do so in a way that imperils the state's position and this board's position that has been taken in curling that our office is unaware of.
Well, let me ask you this, Russ. I'm not so much worried, I hate to say it, my lawyers won't be happy with this, but I don't really care too much about the curling case other than the outcome. I'm not worried about that position, frankly. I'm just worried about making sure that we do the right thing. But I would like to hear from our lawyers as to whether or not they have in fact advocated for the position of a paper recount as opposed to an electronic recount. And for that reason, I want to ask you, is it within my discretion here to move to continue this to the July hearing so that we may consult with our lawyers as to their research, as to the experts who reviewed this for the state, to see whether or not, in fact, based on those experts hired by the state on my behalf, I guess, to see whether or not this sort of paper recount is in fact the gold standard, or whether or not a recount by machine is the gold standard with an audit by paper. So is it within my discretion, Russ, to simply move to continue this so that we can make sure that we get this right? And I respect Ms. Marks. Yes, we're technically an adverse party, but more importantly, we're both individuals worried about making sure that the elections are correct in this state. So, Russ, is that within my power, our power?
So let me preface that I am appreciative of your comments. I am just trying to advise the board as best I can in a matter that is intrinsically tied up in litigation that our office is barred by the rules of professional conduct from becoming involved in or taking any active participation.
And I know that, Russ. I didn't mean that as a rebuff to you.
And I'm going to answer your question.
Yeah.
The answer to your question is no, it is not within your power to continue this to the July meeting. You can either, if Ms. Marks is willing to withdraw her petition and resubmit it for the July meeting, you can do that. Or you can reject the petition. Or you can initiate rulemaking proceedings. But I would urge the board to refrain from doing that just because I cannot advise the board as to what the current posture of the curling litigation is and or what arguments have been made by the board's attorneys in that litigation.
Let me ask you this, and let me ask Ms. Marks, you're going to be part of this. If Ms. Marks were to agree to withdraw her petition, can we take note of the fact that the petition that she's previously that she's put into place, we can make note of the fact that it's resubmitted as is, so that she doesn't necessarily have to file whole new paperwork? Can I do that? other words, I don't want to make someone do an artificial jump through the hoops. If we have a petition, but we want to be able to consult, that we want to be able to consult with our lawyers, and we want to be able to consult with the experts hired by the state on this issue prior to making any kind of rule changes. If Ms. Marks withdraws the petition, can we take note of the fact that her petition has been resubmitted without her actually having to do so? I don't see why we can't, but you're my lawyer. You see what I'm trying to do here?
I believe I understand what you're trying to do. I think you could have an agenda item for consideration of a board rule where you have a draft rule for consideration for the board to consider it for promulgation. And you can note either in the agenda item or what that this had its genesis in Ms. Marks' original petition. But you have to dispose of her petition in one of three ways today. Either you reject it, she withdraws it, or you initiate the rulemaking proceeding.
All right, I got you.
May I?
Yeah.
Okay. Is that Mr. Willard who's speaking? I just heard you reference him as Russ, so I wanted to make sure. So maybe Mr. Willard did not get a copy of our petition because I think he's not aware. He said that we've gone in my stating what the proposed findings of fact were. He said we've gone beyond the petition.
I'm not worried about that.
Okay, I just wanted to make sure
I'm not worried
knew.
about that. I'm trying to, quite
Okay.
frankly, simply get to this point where we can consider your petition.
It will, maybe this will help clarify.
At the next hearing, in order to give us an opportunity to consult with the attorneys for the state and the experts for the state, and take a look and see whether or not we should move forward with your petition at that point. That's all.
Okay.
Seeing how I don't get the benefit of a lawyer from the state right now because he's in conflict.
Understand, but just would like to make this point as well. This issue is actually not at all, I think Mr. Willard misunderstands. This issue is not at all in front of the court. It was not anything that has been debated. He, I think, may be mistaken or having our case confused with another one. This has never been in front of the court. We've never argued it. We don't have a position on it. Sounds like we don't even have opposing positions on it. This was just as Judge Totenberg, in her motion for summary judgment order, was kind of just recounting how elections are conducted in Georgia. That's all.
I understand, but you yourself brought up the fact that the state has made certain recommendations and certain assertions, and quite frankly, I would simply like to be able to consult with our lawyers on that issue, and with the lawyers, and you also cited experts that were retained by the state on this issue, and I would simply like to be able to consult with them before moving forward with a petition. That's all I'm saying.
Okay.
And so that's why I'm going to ask you if you would, with the chair's permission.
I'd like to make a statement first.
You're the chair?
I have read this and read the code, and prior to this meeting, I've learned a lot of new things today. I feel like I need more time to think about this and the implications of it. And so I understand that Board Member Lindsay's going to ask you to withdraw. I would also ask you the same thing so that I can fully consider this. It's a very important issue to me.
It is important, and I think excuse me,
I
I'm
don't
sorry.
feel like I can give it everything I need to give it today, and so I'm asking the same thing.
I appreciate that, and I appreciate your willingness to look into this further. Let me suggest something that might facilitate it on both sides a little better, and that is, if you don't feel like you can move this forward for rulemaking, go ahead and deny the petition with the letter that we get from the board that gives the rationale for denying the petition. And then what I will do is respond to your concerns, tweak the rule that responds to your concern in a way that hopefully responds to your concerns, and resubmit it before the next meeting.
Move to reject.
Move to reject. Any more questions from the board?
I am interested in recounts, using hand recounts, but I would like to know how often recounts are initiated either by the superintendent or by the candidate by margins of the election. And I'd also like, if possible, some assessment of the cost to the counties or the election offices or the state for conducting a recount versus of a machine count versus a hand count. The people involved and the time involved. I'd like a comparison of those factors, if that's possible. I would appreciate that.
I would love to have that information available, but I don't think we can get it. I think the board, through the Secretary of State, probably has the best opportunity to get it, because many of the recounts that we become aware of don't really, there's not much in the way of documentation. And sometimes I'm not sure that they even make it up to the Secretary of State's level of, like, I'm aware of a municipal election in Grady County in last year, year before last, that there was like a 1 vote difference in, and then it went to a manual count. We were aware of it because we were involved in talking with the candidates, working with them, recommending the manual recount. But that, we just happened to hear of it. I doubt there's a bit of documentation anywhere about that. And I don't know that I would get it, that I would know how to find it in Georgia. So I don't want to volunteer to get you something I probably can't find.
Right. I suspect at times there might be some rationale to say it would be easier to automatically move to a hand recount because it's not unusual these days that the machine recount brings into question the programming of the machine or the proper counting of the machine. So rather than doing that and then moving to a hand count, which actually extends the recounting period altogether, maybe there's some logic and rationale to just going straight to a hand recount in these situations.
And, you know, I think that Georgia has an unusual but very flexible law on the discretionary recounts. I'm using the word discretionary. It's not used in the law, but the fact that a candidate, a campaign can, it actually, I think the voters can come in and say, this just doesn't look right, Board of Elections. Will you do a discretionary count before you certify? We haven't seen it used very much, but it certainly would be helpful.
It's not used very much, and it is at the discretion of the superintendent. And it could be a recount of just a precinct or an entire contest.
Or just the absentee ballots, or, yeah, whatever.
Right, and certainly at the discretion of the superintendent if there's an inconsistency or some request by a candidate of an inconsistency.
And that's what our rule recommends, is that decision of the superintendent be a more transparent one. We've seen a lot of candidates go to their superintendents, ask for a discretionary recount, and be told, no, it's not in the law, you can't do it, and won't even call a board meeting to ask. So we were just suggesting that it become a more transparent ask and answer.
Correct. Well, you certainly wouldn't want every losing candidate to request a recount.
And I don't think most would, but if it just looked like it was willy-nilly, then the superintendent would say, no, you're not showing us any reason that there's a problem. But if you were in DeKalb, as I know you were, but if you were in DeKalb in 2022, there was reason to say we better do something, right? And as you recall, initially the DeKalb DeKalb officials were saying the tabulation's correct, the tabulation is correct, when it wasn't.
And they did it against the court order.
Shh, 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 shh. So,
I also would agree that I need more study on this. Not to say that I'm opposed to what you're proposing at all, but maybe some more information to see what repercussions this would have as far as manpower, cost, time in implementing this.
okay, well, when we get your denial and the rationale for the denial, then we will try to respond accordingly and put it back in front of you as soon as you'll have another meeting.
I think I have a pending motion, Mr. Chairman.
I'm sorry,
I think I have a pending motion.
another motion?
No, that's.
Oh, yes, you do have a pending motion. We have a motion from Member Lindsay to deny,
I didn't hear it.
I'm sorry? He did, he made a motion to deny this petition. Do we have a second?
Second.
We have a motion and a second to deny petition. Any discussion? Hearing no discussion, all in favor of denying this petition signify by saying aye.
Aye.
Aye. Any opposition? Hearing no opposition, so moved by a vote of 4-0.
Thank you
Ms.
for your
Marks.
time.
Look forward to seeing your renewed petition.
Okay.
I have one announcement I wanted to make, and I forgot to make it right after lunch. Many of you know that the governor signed the budget yesterday. And in the budget, the State Election Board was given $5 million to conduct an audit of this fall's elections, I guess. This coming falls. We will be working closely with the Secretary of State's office on that, since we have very limited staff sitting right here. To do that, we'll be working closely with the Secretary of State's office. Member Lindsay will be representing the board and the liaison with the Secretary of State's staff to work through the mechanics of effectuating that audit. And Dr. Johnston and I will be working within the board to make sure that the board is fully apprised and plays a part in that audit and are overseeing everything. I would be the person myself dealing with the SOS, but I do have another full-time job. And I know you do too.
Yeah, I just said.
So I just want to make that announcement so that you know going forward we have plans for that, and we'll be working very closely to make sure that that takes place this year as much as we can. Thank you. And the next item on the agenda is, what are we on, 5? Petition for amendment, the State Election Board rule presented by David Cross. I know Mr. Cross is here. He's been here for 2 days now.
I feel like I need a sleeping bag. All right, so hopefully these will go rather quickly. I've got 2 of them. The first one is going to be printing in color for emergency ballots.
Is there a reason you wore a salmon-colored?
One must have a pop of color, you know. It's just, and you should have one too. I don't understand this guy. You gotta dress it up a little bit. All right. So with regard to color printing on emergency ballots, what we're talking about here is I'm talking about literally inserting the word salmon into rule number 183-1-12-.01. The superintendent shall cause every polling place and advanced voting location to have a sufficient number of salmon-colored blank paper ballots that can be marked by pen available for use in the event of an emergency. So the reason for this rule is that there's currently a lack of visual distinction between emergency ballots and standard ballots. And in 2020, Fulton County ordered 1 million emergency ballots, which was 2 times as many of the number of voters in all of Fulton County, and it was 17 times the number of people that voted on Election Day in Fulton County. So also with regard to, this has to do with maintaining chain of custody and strengthening chain of custody, because in 2020 we had Mark Wingate on the Board of Elections,
in his recent testimony in the Jeffrey Clark disbarment hearing, said that, so to pick up where you're talking about, we're asking for not receiving chain of ballot or chain of custody documents. That's the question put to Mr. Wingate. Mr. Wingate responded and said, well, we asked and did not receive any chain of custody documentation. So how can I trust anything? As a board member to certify this election when I cannot receive or even a sampling of anything at all with regards to chain of custody documents, it was just another way of things in my mind leading up to certification that was certainly not fulfilled in terms of providing those documentation or providing that documentation. So even today, if you put in an open records request with Fulton County and say, how many of those million ballots that you guys took in, how many were destroyed or how many were used, they're going to answer with, we have no records, to satisfy your request. So my whole point here is to just simply, you've already got a rule, insert salmon color on there. Salmon color ballots are not going to disrupt the scanners. It's not going to disrupt the technology. And as far as cost goes, because I know that tends to be a big issue nowadays, the cost is roughly 1/2 cent per ballot. And if that is the case, if Fulton County, printed all of theirs in 2020, 500,000 or a million ballots at 1/2 cent apiece would have been roughly $5,000 of additional costs. And for a county like Bartow County right now, I think it would cost them additional $17. So the cost is insignificant in order to satisfy this request. And I think if you've got visually distinctive ballots, it'll make it so that they can't be easily potentially pilfered, picked up, or misplaced. How was that for fast?
The quickest among anybody else. Why make them a different color versus just marking emergency ballot on it someplace?
They're already marked emergency ballot, but the thing is
I don't understand the color differentiation then.
The color differentiation is to make it so that if you're a poll worker or a poll manager anywhere, in any county, seeing those ballots will be visually distinct. They only get used in certain situations. Like the power, like the machines go down, there's some type of, emergency issue that causes that. So you're not going to have just like one person come in to vote and then they're going to use, a salmon colored ballot and then you could easily pick them out. That's not the case. The whole point is to make it so that they're visually distinct. Because if you saw that there were no emergency situations that happened, and then you're watching salmon colored ballots, going through a scanner being counted, you have a chain of custody issue going on.
Mr. Chair.
Yes.
The heading on a paper ballot, a hand-marked paper ballot, has absentee / emergency / provisional. So they right now, as it stands, they can be used interchangeably. So I think this creative idea is to give a visual distinction. An alternative would be to print absentee ballots and separately print provisional emergency ballots, which would be kept in the polling places in precincts, so that the header would distinguish that. But the visual difference is very creative, and I saw this used in municipals this past year, and it's great. It's just a visual, an immediate recognition of a certain ballot that belongs to either a certain precinct. They used it for different precincts actually, but it was great to keep the separation. It actually helped the poll workers keep track of proper choice of ballots to give to voters. So I hadn't thought about it in this use, but I think it's
I agree.
Great
And
idea.
to go back to Fulton County for a second, in 2022 in their general election, they had 112,659 people that voted, by paper ballot, and if 20% or voted, on election day, if 20% of those were printed, and currently the estimate is that they generally, print 10%. But if you double that number, that'd be 22,531 at a half a cent apiece. It would cost Fulton County an additional $112.
I have to say that I think if, I don't know why you picked salmon, but if you wanted honesty and integrity, you'd go with yellow and black.
I'm an Auburn man myself, so we couldn't put orange on those. So. But here's the thing. So the reason why salmon is on there is because it is a color that is least disruptive to scanning equipment.
I'm sorry, go ahead.
I have a real concern about maintaining the constitutional guarantee of a secret ballot. There are very, very few emergency ballots that are generally cast on election day. Generally, it's going to be one or two people who are willing to do it because either there isn't a problem, the problem is resolved quickly, or the voters prefer to return and cast their ballot normally. So if you have a ballot from one precinct that is on salmon paper, then whoever voted on that ballot automatically lost their constitutional guarantee for a secret ballot because their ballot is distinguishable from everybody else's.
Not when it's scanned. When it's scanned, it goes in black and white.
But but the ballots are in there, and it goes into black and white, but it's going to be in grayscale, and white scans white, colored scans in grayscale. You're going to see that, and the ballots, the paper ballots are still there, and there's a very high chance that it would have to be adjudicated because these are hand marked paper ballots. By definition.
I don't know why it'd have to be adjudicated.
Well, it easily could. And did you remember we also now have to have watermarked paper ballots. Everything has to be watermarked. Everything is going through that. Is that the quote that you got for the special watermarked paper that we're going to be using, or just through a regular print shop?
It was two print shops that were talking about specialty paper. They approximated half % per ballot.
Do we know how much the special watermark paper is going to cost per ballot?
Does that matter?
Yes, it does.
Why does it matter?
Because this would also have to be done on special watermark paper and salmon paper. Every ballot paper by law now has to be on the special watermark paper. So that would change the cost a bit. But my
personally,
real
I would.
concern is the constitutional guarantee of a secret ballot.
I don't want to take away anybody's right to secrecy. If it was my ballot, I would have like a blue ribbon, like from a $100 bill, inside a ballot, so that I could see like random numbers on there. Because when we're scanning ballots and looking at them and looking for duplications, you've already been told that so if you and I walk into a precinct together and we vote exactly the same, which I know is highly impossible, okay? But if we did, I can hold those ballots up to the light and your QR code is going to look exactly like mine. Everything else on the ballot is going to look exactly like mine. So right now, the Dominion machines have the ability to be able to mark a ballot that has been scanned, but the Secretary of State has not activated that feature on the system. So I'm willing to do whatever it takes to make it so that we can have better processes in chain of custody. But I think if somebody goes in and they have to use an emergency ballot like that, I think it's going to be a case where you're probably going to have that's going to happen because you've got a power outage or something like that, and everybody who's going to be going in is going to be using a salmon colored ballot.
I've seen time and time again, most voters are unwilling to use emergency ballots because they don't like it. They want to vote regularly, so they'll come back, and you'll only have a handful of emergency ballots every time it's been used.
We heard one of those cases recently where the first couple of people that voted had to use emergency ballot,
right.
And just a couple out of the whole day.
But were those voters designated as using emergency ballots on their vote record?
You can't see that.
Any observer who was there at the time is going to know. Any poll watcher, anybody else there is going to be able to identify, because you can see the salmon ballots from across the room.
But the only way that that's going to happen, I mean, with due respect, is going to be for somebody to observe that. They're going to have to walk over to the check-in station, see who that individual is, write that down, and then report it, somehow. I mean, I think as a poll manager myself, I can't see that possibly happening. I mean, I'm a poll manager in Gwinnett County, and that's just never, you don't see people walking across to try and check out how somebody's voting.
When you're in small counties, people are intimidated to go because they don't want, I've talked to many voters in small counties who are unwilling to vote in primaries because they don't want anyone to know what ballot they pull because it can affect their jobs. So we've got 159 counties to cater to, not just the big four.
Well, even with the big counties, again, I'm kind of going back to, the 141 transgressions that you mentioned yesterday against Fulton County. They got a sharp wag of the finger, and they got there was no financial repercussions. Y'all didn't assign them, you didn't assign them to have to, you didn't assign Fulton County to have to pay, the investigative costs, which you could have done. That's in the rules. I just think it's strange that somebody like Fulton County can go print a million emergency ballots, and they only had 59,000 people voted on Election Day in 2020. It defies logic. It makes me think, what was somebody up to? And the only way that I know how to prevent nefarious actors in the future is to use something that is obvious and color-coded.
Mr. Cross, I just want to make sure that you know. Feel thank you. Make sure that let you know, and for the record, Gabrielle is the organization of our county superintendents, and they raised similar issues to what the board member questioned. This is exactly what and I want to put it on the record. Gabrielle agrees that chain of custody of unvoted ballots is extremely important, but does not agree that changing the color of ballots would assist with chain of custody in any meaningful way. Beyond that, we oppose the proposed rule for two reasons. One was the voter privacy issue. Situations that require emergency ballots may only involve a small number of voters or even a single voter, particularly in rural areas. In those cases, the voter ballots would be easily identified. Two, and not sure if you've already addressed that issue, but feel free to address it again. The second point is the wasted ballots. The rule would force us to order more ballots than we currently do, and that would accomplish nothing beyond forcing us to account for, secure, and eventually destroy an even larger number of unused ballots. It's also worth noting that the print vendor that is referred to in the rule is not a ballot printer, cannot order or procure security paper, and does not seem to know that the actual cost of ballots or take new legal requirements into account. That's CHB 974. I'm just putting that on the record and giving you a chance if you want to respond.
I think that's fair. I mean, the new paper, the new secure paper that's out there. I mean, there's a limited number of people that have access to that. Me as a citizen, if I call up the state and say, hey, who's the vendor, and try to get a quote from them, that's something that I can't do. That's something that the board is able to do.
Are there further questions from the board? Questions?
Do y'all have any concerns about, what I rose about Fulton County?
Yeah, that's why I'm
But a million ballots.
That's why I'm getting a monitor form. Okay, I have a lot of concerns about, that's why I'm trying to negotiate and get a monitor organization in place that can properly monitor. I'm just not convinced that while I understand you're trying to address a particular problem for a particular large county, I'm not convinced that this is something that works well for 159 counties, as opposed to what we're trying to do with getting an organization to monitor Fulton County, or for that matter, should any other county come up. I think that's probably a better way to deal with the concerns that you've raised than the particular color ballots, which may work in large areas, but may have some very greater concerns in more rural areas where there's a smaller number of people who may very well be worried about secret ballots. I just want to make sure you understand that.
Any further questions? Dr. Johnson? No. Chair will entertain a motion.
I move that we accept, I can't remember the correct wording.
Initiate rulemaking.
Initiate rulemaking procedure for this petition. For the provisions of 183.11-.01, paragraph 3. Is that right? No, I'm sorry.
Dr. Johnson, I'm not going to go with you on the motion, but I'll give you the language if you need it.
Yeah, give me the language. Yeah, I can't even find the thing.
Here's the language given to us by our attorney. I hereby move to initiate rulemaking of the proposed petition and proposed petition.
Agree, yes.
No.
In your words.
Yeah, that one.
I'll second your motion.
No, I'm not making it, but I'm not making it for the reason I stated to Mr. Cross, but I'm just wanting to give you the language.
Well, board members, I'm willing to work with whoever's going to be, working on writing this thing up. If it turns out that, that they say, hey, the salmon color, if it's your determination, moving forward on trying to come up with some type of security issue, to make this tighter chain of custody, I'm willing to say, hey, it doesn't have to be salmon. But maybe if the ballots, are printed in such a way that it is obvious on the same color ballot, but it has different wording on it so that they all don't look the same. That's the major thing to be able to look for, because as a citizen, if I'm going through and looking at scanned images of ballots and I'm told that only X number of emergency ballots were used, but I'm finding X plus 1,000, then that's going to lead me to to believe that something happened incorrect.
Our only three choices today are to approve it, deny it, or you can withdraw it and work with one of the board members to revise it and resubmit it.
Can we do that by July, you think?
We have another meeting in July, and you could resubmit it for the July meeting.
Okay,
Yes.
I'll withdraw and rewrite.
Thank you. The petition for rules change has been withdrawn.
I withdraw my motion.
Thank you. Withdraw the motion. Mr. Cross, are you next?
I'm next.
Oh, boy. Keep losing my agenda here.
You said it was really small.
Too many papers. I know, but it's late in the day.
All right, I should be able to blaze through this one as well, too.
You have to let me read.
Yep.
Let me do my part.
Okay.
The next item on the agenda is to hear a petition for promulgation of state board rule presented by David Cross. Mr. Cross, please proceed.
Thank you. So this is a rule that would be drafted regarding meaningful observation and helping to define what meaningful observation means. As it stands right now, meaningful observation should include visual and auditory observation, witnessing, watching, verifying, monitoring of election forms, et cetera, and being able to be close enough that you can see and hear what's going on. As it stands right now, meaningful observation is not adequately defined. Our legislature seems to have a field day using words like meaningful and then not telling us what meaningful needs or what that means. So this has to do with the fact that specifying bipartisan witnesses, how they're to be chosen, how they're and basically how they are supposed to be able to have access to see what's going on during the election. This one was actually written by an attorney who's a friend of mine. So
That doesn't necessarily make it.
That's right.
he's a very, very bright guy. Yeah, I think you all know him, but I'm not going to name him. So in past elections, this is bullet point number 4 that's in the matter. It says in past elections, poll workers have been treated inconsistently among various counties with wide-ranging subjectivity assigned to poll watcher access into election tabulation processes. So we're trying to bring uniformity and definitions to the meaning of to meaningful poll watching.
Let me start off, and I want to read to you once again. Gabriel opposes this one as well. But
Who is Gabriel again?
It's the organization of the county election superintendents.
Awesome.
Okay.
And supervisors.
And supervisors. Let me read it to you and give you a chance to respond. Observation by credentialed poll workers is tantamount to transparent elections. However, portions of this proposed rule are in conflict not only with existing law, but also with newly passed legislation. The proposed rule conflicts with state statutes that govern voter registration, election officials, and poll watchers. For example, poll watchers are prohibited from seeing certain documents explicitly allowed by the rule, as well as reporting issues to the poll manager as the rule would require. It's also worth noting that we do not officially track political affiliation in any way. We do record which primary election that a voter chooses to participate in, but this doesn't imply their party affiliation, just what primary they chose. Just want to give you a chance to respond to that.
Well, we're looking for total transparency. I mean, the United States Declaration of Independence says that a just government is accountable to its people. And based on the fact that y'all have been dealing with a lot of these meetings going on for the last 3.5 years, and I've been dealing with this stuff as well too. Ms. Marks has been dealing with this. Mr. Favorito has. It is very clear that the people of the state are upset with the way that elections are handled or maladministered. The Constitution of the United States of America provides for a series of checks and balances, not only between the branches of federal government, but between the federal and state governments to ensure that the rights of the citizens are not infringed by state governments, including the rights to transparency and accountability. So this is all about bringing uniformity to the practices and the proceedings for all election officials across the state, and again, just defining what meaningful observation is, because as we've seen in the past, and y'all seen on the news before, meaningful observation in some cases was, you can come into where we're counting the ballots. I'm going to be counting them over here on this machine, and you can stand over there in that back corner 25 feet away, and you can watch what I'm doing from over there. I was a poll watcher. I went to Fulton County. I went to State Farm Arena. I couldn't see anything. I mean, I got so bored that I walked over and I started looking at the ballot totes, and I got thrown out because I pointed at one with my foot and said, "Look, that one's unlocked," and they threw me out.
I sympathize with you on this and agree that there ought to be some more standards for meaningful observation. My problem with this is it doesn't really define for me clear enough what meaningful observation is, and your definition and my definition. Your definition as a poll worker and my definition as a observer might be different, My definition might be you can observe it clearly from 2 feet away, and your definition might be I got to be a foot away to see it, And so I think that it needs a little more work to kind of set some boundaries on what meaningful observation is, because it's just still open to a lot of interpretation here for me. But I agree with you that and having dealt with some of these cases already, that there's a lot of inconsistency out there, but I just think that it needs a little bit more definition than what you're suggesting here. So we can, some language as to distance, maybe what,
That's
for
fair.
me,
That's
I need some more context here.
Okay.
So.
Correct me if I'm wrong, please, but I believe that we just now, as of yesterday, have a new law on the books that poll watchers may be as close as practicable with the legislature.
Again, a useless word.
Yeah, what does that
Yes
mean?
and no. You know, like, so because meaningful observation absolutely
Yeah.
requires that you can see the processes that you're allowed to see and that you can witness that. But my problem is this law not only mandates that counties, that bipartisan teams must be part of all of this, which means if a county cannot find a bipartisan team, or if somebody doesn't show up, they can't conduct their election appropriately, the way it's written. It also has the teams actually undertaking the activities, because it says that they shall observe or undertake. And that turns the entire election staffing on its head. And that is, so they would not be sworn poll officers working and actually undertaking the election, but it would be the bipartisan teams. Some states do it that way, but our legislature has not created that structure. Our legislature has created a structure whereby the onus is on the parties to decide whether or not they have the volunteers to do it, and they must be allowed. But to say that these processes must be overseen means that you've hamstrung counties where they can't actually find volunteers. And I've heard time and time again, because there are certain activities that have to be undertaken by bipartisan teams, like vote review panels. And some counties have a devil of a time finding volunteers just to show up to be on these panels. To increase the pressure on the counties to find bipartisan teams before they can undertake any of these activities would really grind election activities to a halt in some of our counties. We wouldn't have a problem finding folks in metro areas, but in Ben Hill County, if you can't find a bipartisan team, and you can't, and the state party can't find somebody to send down to Ben Hill County, and frankly, I don't want somebody from Atlanta down in Ben Hill County. I want Ben Hill County folks to do those elections. So the structure that's been created here, I think, is unworkable with 159 counties.
Do you think it might be something where we could, where we could put something in there about, having that the superintendent, has to ask for volunteers before unilaterally just assigning people? Because Fulton County just unilaterally assigns people, whereas I know other counties, try in good faith to go out and find volunteers.
Well, I think the onus has to be on the parties to find and assign their volunteers, and then the process is that the parties find the people that they want in the polls and in the tabulation center, and to monitor the absentee process. That's the structure that the legislature has put forth, and I think that's where the onus has to remain on the parties to identify the folks, and then the counties to allow them to observe the processes. But to allow them to observe the processes that are defined in statute, because this goes a little bit further than that.
Okay. So you just help me out as far as like understanding what you think is like also like meaningful observation. I mean, like anybody. I mean, like like John, you said 2 to 4 feet, depending upon who it is. I mean, because my eyesight might be terrible and yours might be great. So
You're right, but everybody has their own personal space, and the last thing you want is a poll watcher looking over somebody's shoulder and almost physically touching them. So I think there's got to be, I don't know what that number is, frankly. I just know that we need to define it a little bit better. Maybe it's 2 feet, maybe it's.
that's fair. I mean, I'm just trying to get a sense of like what the board would might be willing to entertain. So
I just like it defined a little bit better than what's in here, and I don't know the answer to that.
Totally fair.
Right now, so
Okay.
can you understand what
Yes.
my concerns?
And perhaps, if I may, Mr. Chair,
Yes.
and perhaps sort of focus on not so much even the distance, but what you want to be able to observe. For instance, you gave a good example a little bit earlier when you talked about you went down to the State Farm arena and you got so bored because you couldn't really see anything. What, in terms of distance, don't so much worry about feet, for instance. Worry about the distance has to be close enough for you to see X, Y, Z. And that I think oftentimes gets you around that other issue of some artificial number, because if I don't have these glasses on, I'm toast.
Right, but maybe it's should be able to observe within a certain distance.
Yeah.
You know, so it's not, so you'd be able to observe it within 5 feet or
Within
you know.
5 feet in order
Yeah.
to see X, Y, Z.
Okay.
And sort of focus your proposed rule on, all right, you know, what are the key things you want an observer to be able to see? And
Bless you,
focus,
bless you.
and, you know, that observer, you know, and have a caveat, while not interfering with the operation, must be able to see X, Y, Z. And sort of focus on that.
Okay.
In terms of the rule.
Okay.
Mr. Chair,
Yes.
several things to address. What you want to see is important, and as I read this, I would say that an observer would want to be able to see the numbers on the counter. But just as if you were a candidate running for office, you would like to, as the votes are being counted, you would like to be a witness to that, or the observer would like to be a witness. So they should be able to read the numbers, and whether that's reading the numbers on a scanner or a server, they should have access to seeing those numbers as they roll up or as they count up. And one way to maybe, rather than leaning over someone's shoulder, would be to, for a county to offer a camera display of a camera on those numbers to project it on a screen.
Okay.
So observers, you see the camera, it's on the screen, now it's projected up on, on a big screen for everyone to see without you hanging over and passing.
Yeah, that would get rid of the concerns about interference.
That can get real expensive, though. If
Right.
you're talking about multiple scanners, multiple numbers, and having to put them on the screen, I mean, that can get real expensive, I think, for some of the smaller counties or some of the bigger counties, frankly. Yeah, I mean, it's a good thought, but I just see that as being a possible technological problem.
As an alternative, though. As an,
Yeah,
that counties can have the option of doing one or the other.
Correct.
Allowing in
Yeah.
person
Yeah.
or providing.
It's fairly inexpensive to live stream, like I mean, our phones nowadays are like 2K. I mean, they're unbelievably, good quality images. So I will, to save us time and let y'all get moving on, I will withdraw this with the understanding I can bring it back in July with tightened up language.
I'm already starting to like you better.
So wait, but I have a few more
I think we're already
comments.
Yes.
scheduled to see you anyway, right?
Only because you love me.
Right.
So we will accept your withdrawal. I'm sorry.
Yeah, I had a few more.
Oh, I'm
comments.
sorry. I am so sorry.
He's withdrawing.
You guys-
No,
Y'all are
she has some
talkers.
suggestions.
What is
It might as well get them on the record.
I'm
Get him
just
on the
being
record, but
polite.
I will say this, my only caveat is we have
All
to
right.
close out at 4:45, and I want to get to the
Well, I
last
think,
person.
All right.
I think Member Gazal actually is leaving here in about 5 minutes. We will still have a quorum. We'll be able to finish the last one.
I just want to.
And Rick had something too.
He's still on here.
He's still
Okay.
on, yeah.
All right, and as I read this defines meaningful observation of particular items, none of which are PII. So these are numbers, forms, closing tapes, whatever, numbered voter list, nothing that is PII, actually. So I like that. And the issue with the stopping the election process because the bipartisan team is not available, I read this, that the superintendent shall proceed with ballot processing as scheduled.
Correct.
So if
If
whoever the
they
party
can't
didn't
find people,
provide,
yeah.
then the superintendent proceeds on. Correct?
It
Am I
does,
reading that
it does, but you know what? I would like to have something in there that says that the superintendent, should have to reach out, to the parties ahead of time and can't just unilaterally decide that that's what they're going to do.
Okay. All right. I'm done.
Thank you.
Thank you.
Thank you for your withdrawal. We greatly appreciate that. The next item and last item, well, I take that back. We have one more item after that on today's agenda. Would you like to go ahead and leave? Member Gazal will be leaving. We still have a quorum in place. Member Jeffries is still online?
Still on, yes.
Okay. Member Jeffries, are you still online?
Yeah, I'm still here.
Thank you, okay. The last item on the agenda, the second to last item on the agenda today is petition for amendment, the state election board rule presented by Michael Heekin. Mr. Heekin, please.
Thank you, Mr. Chairman and members of the board. We've already had a fulsome discussion of certifying elections today. I just want to share a personal experience. I'm a fairly new member of a board of registration and elections. Last fall, we had municipal elections in Fulton and other places. There were some issues with the state new voter information platform, which I'm optimistic and are being worked out, but also we had some issues with redistricting. People weren't getting the right ballot styles, et cetera, et cetera. So when it came time for us to certify the election, I thought I would just open the Green Book and see what the definition of to certify the results of an election is. It doesn't exist. I think that it would be helpful for us, speaking personally and for every other Board of Elections member, we don't like to vote no on certification. Anything you could do to help us get to the truth would be greatly appreciated. So one of those things, it's an early, modest step, would be to define what it means to certify the results of an election. Started researching this. I came up with the best definition available is the United States Election Assistance Commission has an entire publication on election certification. I suggest that the board adopt their definition of certification, which reads that the process of election is the process of election officials attesting that the tabulation and canvassing of the election are complete and accurate, and that the election results are true and accurate accounting of all the votes cast in the election. And I would suggest to you that we add to that simply certify the results of primary election after reasonable inquiry, because it makes it clear that this is not a ministerial act where I take out a stamp pad and stamp it and say hereby certified. There's a higher order mental processes that go on in this. And if we could get this definition, I won't get any more nasty letters from lawyers threatening to put me in jail if I don't certify. Okay. So I urge your approval of this modest improvement to the election laws of the state of Georgia.
Can I ask you, if I may, Mr. Chairman?
Yes, please.
Can I ask you if, we're already taking up this issue. You were here earlier and testified. Can I ask you if you'd be willing to withdraw your petition with the understanding that you're going to work with us when we come up with what we were already talking about in terms of the necessary information that you should be receiving prior to certification? I understand the definition, but I want to try to do it all together. You guys should be getting certain kinds of information. I think we are all in agreement of that, and we all want to try to figure out the language that needs to be done in a particular rule, so that prior to any certification you have that information, and then incorporate a definition that you'd be comfortable with in one rule rather than trying to do it in piecemeal. That's what I'm asking you.
Yep, I want to say yes because it's almost 4:30. I want to understand the process better, because the definition of certification, regardless of what, in fact, this would guide what you need, putting together the information needed. So why not get this in place now?
Well, we're not going to be able to get it in place anyway, because you heard the process that has to take place. So I guess what I'm saying is, it's not a matter of us voting and it's suddenly in place. We're going to be having to go through.
There's rulemaking.
There's a lot of rulemaking steps that have to be done before we get to that point anyway. And since we're already going to be dealing with your issue in terms of what information you should be getting so that you can have a meaningful certification, I just want to be able to do it together. It's not, we fortunately have a little bit of time before November. And I'm simply asking you if you would be willing to let us do that.
I certainly want to cooperate, but what I'm saying is,
I hear what you're
is that if you understand what's the bogey is the tabulation, canvassation, da-da-da-da-da, then you'll be guided by what we need. But I would defer to the board if that would assist in getting this done, because I'm incredibly excited. We want to vote yes on certification. I'm incredibly excited that the board might help us, help the directors of election exactly what we should be able to see before we make the certification vote. If withdrawing this assists in that effort, and if the good faith expressed here today continues through for another 2 months, would be happy to do that.
I would love to initiate rulemaking for this, and in reviewing the history of the rules that we have, I've seen there are rules that were approved and adopted, and then actually 2 months later, there's another one, a revision or an amendment. So it's not that we only have one chance to get it all perfect. We'll
Sure.
never get it, make it perfect. But so I would like to initiate this because it provides a guideline for us to work from to proceed on with Ms. Thorne's recommendation.
Good.
Petition.
I misspoke by saying the good faith that was permeating the room. I would say the excitement and the teamwork. I wasn't questioning anybody's motivations.
And I understand that. I hope you understand. 'Cause keep in mind, anytime that we make any tweaks, we have to start all over again, as our attorney said. And the fact of the matter is, we are more, petitioners already give us some language that we can start to use or something similar to it.
Sure.
Anyway, I'm simply saying that in all likelihood, we're going to be looking to try to incorporate language like that into any other rule anyway. So I'm just not sure where we're getting to if we go ahead and move forward today versus we have your proposal.
Mm-hmm.
I mean, and this is something that or something like it that we probably will need to put into any particular rule. But since we're going to have to be revising the other issue anyway, and be coming back and working in June or July on that, I just was trying to cut things short.
Sure.
I see.
The question is whether we take this language and just add to it to include what we think the documents ought to be that they're able to have access to. So it's just, it's instead of the paragraph being like this, it's,
Correct. But if this is initiated now, then if the other one may be bogged down with questions or wording that goes on for several months. This is rather short and sweet and to the point, and I think I wouldn't hesitate to proceed on with this, and then we can accommodate as the other petition comes on board again, because that will have to start from the beginning. This could be in the process already.
I do have a question. This is identified as C.2.
Of the definitions, I believe the second rule in the SEB rule set is definitions, and this would be C.2. It's a funny if you look at the rule, you'll see why I did C.2. I don't have it pulled up right away, but it was. I think there's already a C or let me pull it out.
Okay, I have 183, 112. 112-.02, and there's a C referencing ballot style. Am I looking at the wrong?
Let me see here. Let me see what led me to believe. Okay, definitions. C, ballot style. Certify. Oh, they're in alphabetical order. And certify would be after B for ballot style and before E for electronic. That's why I did it.
2, and C, ballot stuff. Oh, so just be a new paragraph, Mr. Heakin? C.2?
What, yeah, I mean, I'm sorry, what's the right answer? No.
Somewhere between C and D.
I was a math
C and a
major, but the
half.
last time I went to school, there wasn't a letter there, so.
Okay, my mouthpiece just said, or I could, no, I'm sorry, he's not my mouthpiece, but we could just make it renumber the definition things and rather than glom it up with C.2.
Renumber.
Yeah.
All right. Mr. Chair, I move that we initiate rulemaking procedure for this petition and initiate renumbering at the same time for Rule 183-112.02 definitions.
And so you're renumbering then D through O?
D through O. Relettering. D through O.
The General Assembly a lot. Like renumber.
Just renumber.
I'm sorry, I'm trying to also, there's a proposal by Gabrielle, some additional language. I'm sorry, I was looking at that.
Oh, okay.
Motion's on the floor.
I know.
I second it.
You got a second here.
Well, the question is,
And let me ask the person, Dr. Johnson, who made the motion, would you be willing to add the following additional language? This is language that's proposed by Gabrielle.
you can't,
Yeah, that's a friendly amendment.
I thought we had to either pass or deny this one. We can't make alterations to
Pass
it.
it and work on it. Isn't that right?
We worked on it.
Initiate rulemaking with the new language? Okay.
Yeah.
All right.
Dr. Johnston, this was suggested by Gabrielle to add, and I would like your inquiry as to this as well, because the concern is that request be made timely, and that it is the duty of the official making such inquiry to ensure having a sufficient time to complete the inquiry prior to the scheduled certification meeting.
I don't think that, I wouldn't see where the definition of certify the results, that doesn't say that there's no time, it doesn't compress the time for them to I would be concerned because this is just a clean definition. It's not putting timelines in there or anything, but.
Yeah, it's just making sure that within the definition, there isn't a built-in ability someone to basically delay, to unfairly delay certification. That's the concern.
Yeah. May I suggest to you that may be, where that issue will arise would be more Ms. Thorne's rule than my rule. Exactly what do you have the right to ask for? We're just setting.
I agree. I think that I would keep this with definition, keep it simple, and use that suggestion with Ms. Thorne's petition.
If I could, I mean, I would suggest that if we just had a definition, you're providing true north. What are we heading toward by the definition? But
yeah, I just think that because you have the term reasonable inquiry, that it ought to be a duty. Since you have the term reasonable inquiry in there, that there ought to be a duty on the part of someone such as yourself to ensure that that's done in a timely manner so that it does not unduly delay certification. I think that since you've got that term in there, that this additional language needs to be in there.
My reply to that would be reasonable. We all know the timeline. It's late, you close of polls on Tuesday, you vote Monday at 5 p.m. So what's reasonable would be what's reasonable in the time frame. And we need to be reasonable on this, or else we aren't going to get anything. And I want to vote yes on certification.
And I appreciate that, and yeah. I want you to vote yes. You are on the board of my county, and I want my county to do right too. Anyway, I think this language is important, and I would simply ask that it be included.
Could you read the language again?
The language would be at the end of that of the sentence. It is the duty of the official making such inquiry to ensure having sufficient time to complete the inquiry prior to the scheduled certification meeting.
It's not a definition.
But it fits within the term reasonable inquiry.
I just don't think it fits within the definition category.
I think it fits within, given the fact that you have the term reasonable inquiry in here. That's why I think it's important.
Again, my reaction would be that the task at hand with Ms. Thorne's rule is to come up with something that you can get between Tuesday evening and the following Monday afternoon, and so that's what's reasonable is what's reasonable relative to the time. I think it doesn't sound like a definition to me, but
well, quite frankly, that's why I kind of wanted to delay and do this all together rather than piecemeal.
I don't have a vote.
I do appreciate that, though.
My motion stands.
We have a motion and a second. Would you repeat your motion, please?
I move to initiate rulemaking procedure. Beg your pardon? I move to initiate rulemaking procedures of the petition as written for 183-112.02 with the renumbering of the rule as required.
And we have a second by Member Jeffers on the phone. Any discussion?
I guess the only discussion, I'm going to vote no, but I want you to understand why I'm voting no, is that I think that this ought to be encapsulated into the larger issue that we're going to be taking in July. I want you to have what you need to have in order to certify, and I want you to be able to and I want the definition of certify to be within that, but I also want certain duties placed on you to make sure that you don't delay so you get things done. And I think that all should be encapsulated. And
that hasn't been the problem so far.
No. I'm not saying it has. Yeah. But once we put this in place, yeah. I don't want it to be the problem in the future. I still live by the doctrine of be careful. This is what I was told when I first got elected. Be careful what you pass, because most of the problems today are the result of yesterday's solutions. So I want this solution not to create additional problems.
That's what.
Yeah, I know, and I've voted for a few of these things, and I'm regret.
More work for the board.
Yeah. Anyway, I just want you to let you know why.
I understand.
We have a motion and a second. We have finished discussion. All those in favor of passing the motion as identified by Member Johnson signify by saying aye.
Aye.
All those opposed?
No.
The motion carries by a vote of 2-1. We have, that is the end of the official agenda, but we have one more item to add to the agenda. The chair has been notified that Member Jeffers would like to make a statement. Member Jeffers, you have the floor.
All right, thank you, Mr. Chairman, board members. I want to apologize for being late yesterday, but I was fulfilling my duties as president of Georgia Rural Water at our annual conference. But I would like to make a reconsideration motion, if that is possible.
You may make your motion.
Okay. Review of case 2023-025 suggests there is sufficient evidence that multiple violations have been made. I move that we reconsider a motion concerning case 2023-025. I move that we refer this case to the Attorney General to investigate and review the failure to provide or retain 173 required documents associated with the 10 named advanced voting scanners from the November 3rd, 2020 general election.
Member Jeffers, the chair is ruling your motion to be out of order since it was not properly initiated and noticed and placed on the agenda. The chair will inquire with legal counsel as to whether this motion can be heard at a future meeting, given that the board has previously ruled on this matter.
Okay, thank you.
Thank you. Are there any other items coming before the board today?
Mr. Chair, I have a motion.
Yes.
I move to review the case 2023-025. It suggests there's sufficient evidence that multiple violations occurred when Fulton County failed to retain ballot images for 17,852 counted votes from the November 3rd, 2020 election recount. I move that the State Election Board initiate an independent investigation of the authenticity of votes associated with 17,852 missing ballot images from the November 3rd, 2020 election recount.
Thank you for that motion. The chair rules that motion out of order since it was not properly noticed and placed on the agenda. The chair will inquire with legal counsel and as to whether this motion can be heard at a future board hearing.
Thank you, Mr. Chairman.
Are there any items to come before the board today? Do we have a motion to adjourn?
Move to adjourn.
We have a motion to adjourn. Do we have a second?
Second.
We have a motion and a second. All those in favor of adjourning signify by saying aye.
Aye.
Any opposition? Hearing no opposition, so moved. This meeting is adjourned. Thank you.